Okay, it's a little bit after 8:30, and I'd like to see if everybody could get to their seats. If there's anybody outside that we can make sure everybody is in. And if you want to move up further, that's okay. I promise not to call on anybody. And it certainly might make it a little bit easier to participate and to hear. Anyway, thank you all for coming this morning. My name is Nick Akerman. I'm a partner here in the New York office of Dorsey and Whitney. And let me introduce to you the other panelists that are up here with me. Starting at my left, R.J. Zayed, who is a partner of mine from our Minneapolis office. He's the head of the Government Enforcement and Corporate Investigations Group. And to his right is Mark Schildkraut, who is the intellectual property lawyer at Becton Dickinson. And we're going to be starting with him because he's got a very interesting story to tell, and we'll get to that in a moment. To my right is Ed Stroz. Ed is a principal in a company called Stroz Friedberg, which does forensics and computer investigations. Ed used to be the head of the FBI computer fraud unit in the New York office of the FBI, and obviously brings a unique perspective to this entire issue. And to my further right is Bob Cattanach, who is a partner of mine from Minneapolis, who specializes in, among other things, cyber security and privacy issues. So just to give you kind of an overview, we also have people that are listening in on a WebEx today. So they cannot participate. They can, however, write in questions which will then be brought to us, and some of those we may answer. And I encourage this to be pretty much an open-ended session. I mean, we have a very specific outline of what we want to cover. We're going to look at a real-life example of something that happened about a year ago. And we're very fortunate to have Mark Schildkraut with us, who is, as I said before, the intellectual property lawyer at Becton Dickinson, who's going to take us through a real-life breach that they had last year. That he's we're in an unusual position where he's really offered to kind of lay out what happened, what the problems were, what went right, what went wrong, the different aspects of it, which I think will make a very good starting point to sort of talk about, how we deal with competitively sensitive and personal data, what are the various legal options that are available to companies, examining the self-help option when you can actually do something on your own, when it is advisable to go to law enforcement and bring law enforcement into the picture, how you go about investigating the breach, the roles of various company officials with respect to these issues, and what you can do to prevent these, at least not prevent, but at least to minimize breaches in the first place, and how you respond when there is a breach. So as I said, we're going to go through this. I encourage people here to ask questions. If your question relates to something we're going to get to in a few moments, I will just indicate that and we'll move on. But I'd like to make this as interactive as we possibly can, so that I really encourage people to participate. But let me start with Mark Schildkraut. And maybe, Mark, you can kind of tell us, first of all, what does Becton Dickinson do? Give us a little background on the company and kind of what you do there.
Yeah, sure. So Becton Dickinson, also known as BD, is a Fortune 100 company, or Fortune 500 company, certainly. It's a medical device company. We make a lot of consumables, such as blood collection sets, syringes, a lot of diagnostic equipment as well. We've been in business for over 100 years. We have 28,000 employees throughout the world, employees in almost every country throughout the world, and our products touch every country. And our mission is to just help people live healthy lives.
Well, let me ask you this. How important is it to you in terms of what you do and what you develop as to competitively sensitive information, trade secret information? How does that play into your business model?
So, I mean, I'd say intellectual property in general is very important to BD. It's very important to the success that we've had over the years. As I'm sure most people here appreciate, without IP and without IP protection, we would not have the ability to have commercial success, which goes hand in hand with us being enabled to make these products that really touch everybody's lives.
And you spend, how much of your budget do you think is spent on developing new products and kind of cutting-edge sort of products to give you an edge in the marketplace?
I don't have the percentage at my fingertips, but I will tell you that we do spend many millions of dollars on R&D, on intellectual property protection each year.
So let me take you back to last year.
Okay.
You had an employee that you suspected of stealing data on a particular device that was being developed, right?
Yes.
What was that device? Can you kind of give us some details on that, without spilling the beans, of course? So
the device is, and this is everything that I'm talking about today is publicly available information, of course. The device is what we call a DLP, a disposable liquid pen injector. It's basically enables a patient to self-inject themselves with a drug such as insulin for diabetes, or a certain drug for rheumatoid arthritis, or for other types of conditions where they need to have an injection on a regular basis, and it allows them not to have to go to a healthcare professional once a week, or once a day, or multiple times per day. It's a very important product. This line of products, just pen injectors in general, are very important to patients, and of course very important to device manufacturers as well.
And you had a particular engineer who was working on that project, right?
That's correct.
And what was his name?
His name was Cattanach.
And there came a point when suddenly you were suspicious that this person was doing something that was out of the ordinary, let's put it that way. Maybe you could describe how this all came about and how it was brought to your attention.
Sure. So I guess two events kind of came together. The Friday before Memorial Day of 2013, this gentleman tendered his resignation, and as a result of that, and because of the sensitivity of this project and certain events that happened in the past that maybe we'll get to, we were able to detect that he had downloaded a large number of documents, an enormous number of documents, just in the weeks leading up to his resignation. Interestingly, even if he had not resigned, we had learned that he had also been sending some emails from his BD account to his personal account that was attaching certain BD documents, and that we actually identified a few days before he tendered his resignation. So there was a plan to actually have a discussion with him the following week. But again, on that Friday, he tendered his resignation before Memorial Day, that Friday before Memorial Day, and then we learned about this other activity that was even more problematic.
Now you say the other activity being the downloading and the sending of the emails to his personal address.
So again, two different activities. One was he was sending a number of documents to his personal email, but the real serious activity, just from a magnitude standpoint, was that we had learned that he had downloaded thousands of documents to. Sorry? There you go.
Right.
So he downloaded thousands of documents onto a removable storage device.
So having seen that, and obviously, I mean, this was a person who, if he was leaving, didn't have a legitimate business reason to be downloading these documents, right?
That is correct. I mean, it was very curious. First of all, the sheer number of documents was alarming to us. And then this is a gentleman or a person who was downloading weeks and days leading up to and the day of his resignation.
So what did you do? I mean, what did the company do? And maybe you could describe, what the options were and how you went about deciding where you came out on this.
All right. So first of all, again, he did tender his resignation on a Friday. It was on Tuesday that our information security group identified that all these documents were downloaded. That was brought to the attention of his manager, who looked at the report, and then shortly thereafter, I was contacted. So One thing that we were very fortunate about was the fact that our information security group acted very quickly in terms of identifying this. It was very fortunate that his manager wasn't on vacation for a week, didn't push that report to the side and say, I'll get to it maybe in a week or so, which, we're all busy. That could have been maybe understandable. One fact that did not come out yet was we had also learned that he was planning to leave the country. He's a national of India, and he was planning to return to India. And we also knew that his visa was expiring in about a week and a half after we learned about the download. So once I learned about it, learned about the downloading activity, saw the report, learned that we didn't know exactly when he was leaving, but we had reasons to believe, based on what he told people and based on his visa expiring, we knew he was leaving within days. It was really important for us to act quickly. I'll tell you, if we would have waited 2 weeks, 3 weeks,
everything would have been gone. The cat would have been out of the bag. So what did you do? I mean, here you are, you're presented with a situation where clearly the employee has no legitimate reason to download these documents. In the old days, this would have filled up boxes and boxes of paper, am I right? I mean,
right.
I mean, this really points up the danger of data and what people can do with data and how easy it is to steal it, I suppose.
Right. So we did various things. So first of all, for reasons that maybe will come up later, and you'll hear that we do not treat every circumstance the same way, and we give that advice generally. But first of all, when he did tender his resignation on that Friday, we did actually ask him to leave that day. So he was gone, but we didn't know about all this downloading that had taken place. We learned about that a few days later, after the holiday weekend, and then we internally we identified the fact that we needed to do something quickly to, one, ensure that this information was not disseminated if it wasn't disseminated already, and if it were, that to try to minimize the damage at that point. So what we did is we did contact outside counsel, and we evaluated various options. In our case, again, we needed to move quickly. I think you always need to move quickly, but in our case, we really needed to move quickly because we knew that it was any day that he would be leaving the country. And we evaluated two different options. One was to go and bring a civil action so we can get a restraining order, which we did do that. And the other action that we considered, and we initially stayed away from, initially for maybe a day, was engage in the U.S. government and see if we can get help from the government.
Now, obviously, the problem with the restraining order is if the person's going to India, it's kind of hard to enforce a restraining order there. I mean, was that part of the discussion that you had within the company?
That certainly was. And just to go back a step, so we went to New Jersey Chancery Court, where that court does have the ability to, one, conduct emergency hearings very quickly, and they can give injunctive relief. That's the reason why we went there, and we appealed to the court that we need to make our motion in an ex parte manner, because if we had served anything upon the former associate BD, upon Manier, who knows what he might have done. Maybe he would have left the country sooner. Maybe he would have destroyed what he had, which maybe that would not have been the worst thing. Or maybe,
but there was no way to guarantee it would have been copied somewhere else or sent
given
over
to somebody.
Right.
Exactly. So we were fortunate that the judge was willing to entertain our motion in an ex parte proceeding. Within the Friday, we learned about this on a Friday. We went to court a few days thereafter, and that Friday after, within a week, we did have a temporary restraining order in hand, an order that we actually never had served on him, because we actually then internally started to evaluate whether we wanted to go forward with a criminal type of path.
So why don't you describe what happened there? I mean, this wasn't something that was sort of an obvious option, was it?
Right. In fact, to the contrary, some of the advice that we received, and it certainly could be good advice, was just be careful if you bring in the U.S. government, and again, just be careful, because the question is how will they respond and what will they ask you to do, and here we actually had a very, very good experience with the help of the U.S. Attorney's Office. We thought the FBI did a great job. But again, there was some concern that would they say, all right, this is now something we're handling, this is an investigation, well, please step aside. And in fact, it was the opposite. One, they took it very, very seriously, and I can give you some details as to how that engagement took place. They took it very, very seriously. And two, they actually said, BD, do what you think is right on the civil side. We're not going to tell you to step aside. But because we sensed that they were taking this so seriously, and we can get into the details in a moment, we actually slowed down. We held on to that temporary restraining order, and we never had it served on Manier because we just had the sense, and correctly so, that the U.S. Government was taking this seriously and moving very quickly.
Now, this was the United States Attorney's Office in the District in New Jersey, correct?
That's correct. That's correct.
And what did you really plan to do with this restraining order? I mean, if this individual just ignored it and went off on his plane trip, I mean, did you consider that fact?
Well, yes. I mean, part of the restraining order did include seizure of his passport. So it would have been very difficult for him, perhaps not impossible, but it would have been very difficult for him to get out of the country. So that, in that regard, it was quite fortunate. But again, we were quite concerned about what would he do with the information that he had taken from us. So just to give you a little bit more color, we were fortunate also that our general counsel had just recently attended a panel where somebody from the U.S. Attorney's Office actually was talking about the fact that the U.S. Attorney's Office is taking this type of these types of activities even more seriously, and that if a company does have an issue, we were encouraged to reach out to the U.S. Attorney's Office. So right there, we're in our general counsel's office. I actually made the recommendation that perhaps we should not bring in the U.S. government because I heard perhaps that could get in the way of the success we were having so far on the civil side. And we made a decision, you know what, we're going to call anyway and see what the U.S. government, how they responded.
Who did you hear that from?
We heard that from our outside counsel. That's just based on their experience that could happen.
Yeah, and let me just say, I have to sort of repeat the question when it comes up because we have people on the WebEx. But the question was, well, where did you hear about the problems with bringing in the government? And that's the question that's being responded to.
And they said that could happen, and I imagine that again that probably has happened at times, and that's why I think one of the themes from today is to evaluate what your options are and see how those options are going. We were very fortunate on this Friday afternoon. We had a feeling we were going to get that temporary restraining order. We did get it later on that afternoon, but we actually our general counsel with me and one other attorney in the room said I'm going to call the U.S. Attorney's Office, called this contact that I made, and he explained the situation and said, is this something that your office would be interested in? He said yes. He actually said, I can have the FBI on the phone with you within an hour. He did. He had 3 agents on the phone with us within an hour. And as we continued to see that type of activity, over the weekend they were working with us. By Monday, they were working with us, and by Monday evening they took took action. And there was absolutely, at that point, there was no reason for us to, we didn't shut down the civil action, of course, but there was no reason for us to start serving this temporary restraining order on Manier.
Now, when you say by Monday they took action, this would be Monday of Memorial Day, right? I mean,
no, this is the Monday
afterwards?
Yeah, so again, on Friday, the Friday before Memorial Day is when he resigned. It wasn't until about Tuesday, Wednesday after Memorial Day that we completely appreciated this activity that he had done. And by Friday, we had both the temporary restraining order later on in the afternoon, and we also had the U.S. Attorney's Office supporting us. So it was the following Monday then, so now a week and a half after he had resigned, that the U.S. government, they didn't tell us, but we were sensing it, and we learned later on that night that they were prepared to, they had already made a decision that they were prepared to go to where he had been residing at the time to see what they could find.
And what did they do? Why don't you just describe what happened after that?
So,
and by the way, just so everyone knows, in the materials that we have today, in tabs 4 and 5, we have the information on the civil action that was actually filed, and then you'll see in 6 and 7 will be the criminal complaint and then the information that ultimately this individual wound up having to plead guilty to. I don't want to give away the whole story here yet, but anyway,
had he not,
there's a good ending to this story.
And had he not pleaded guilty, I don't know if we would be able to talk so freely and openly about this. Until a few weeks ago, this was still an open matter, and again, it's a matter that we not talk. We talk in generalities about it, but not freely about it. So I'm happy that it was brought up now. But I guess over that weekend, remember on Friday we had contacted the U.S. Attorney's Office, and now we were on the phone with the FBI somewhat regularly. And there was two things. One is the U.S. Attorney's Office and working with the FBI was trying to substantiate everything that we've been telling them. So we were giving them a lot of information about what we do at BD and what this person had done. That's on the one hand, and then there was also the practicalities of how do they engage him if that's what they had decided to do, and ultimately they did. He had moved out of his home already. He was actually in an extended living hotel in Bergen County in New Jersey, and the FBI needed to know where he was. So we actually brought him back into the office because he was walked out quite quickly. It allowed us to continue on with our exit interview that we do with every associate that leaves BD, and it also gave him one more chance. Not that he knew everything that we knew, but it gave him one more chance to say, we asked him pointed questions. Yes, I actually do have some information, BD, and here it is, or it's in my hotel room, and I'm happy to give it to you. We did ask questions.
So let me just be clear. So in other words, after you got the restraining order, after you reported this to the FBI is investigating it, you then decided to ask this guy to come back in to continue his exit interview.
That is correct.
And I assume you didn't tell him, oh, by the way, we have a restraining order.
That is correct.
And you didn't tell him, oh, by the way, the FBI is on your butt at this point, right?
That's correct.
And so what was the whole purpose of that? To see if you could learn more? Did the FBI even know that you were doing this?
Yes, the FBI knew. Our purpose was to learn more, give him one more chance to explain to us whether he did download any information. We did not, again, tell him. We didn't want to tip him off in case he was not going to cooperate, which he did not. But we also wanted to. His manager, we had HR, we had legal, which is a common practice with anybody that leaves our company. But it's a very common practice for us to ask and remind associates of their ongoing obligations, not to take any information of BDs and not to use it in a way that they're not supposed to, and then if they find anything or have anything to give it to us immediately. And he said he did not have anything, even though we had IT reports suggesting the contrary. So that was a major part of it. It really was in earnest to have that interview, but also to tighten up any loose ends to successfully enforce what we need to enforce if we had to.
And did the FBI know that you were going to do that interview?
Yeah, they were on our premises. They
were on your premises? And how did you memorialize that interview? What did you do to do that?
We took notes. There was a recording as well, and the FBI had a copy of that, and the U.S. Attorney's Office had a copy of that recording, audio recording. And
so he leaves your offices, and what happens after that?
That evening, his premises, he was staying in an extended stay hotel room. His premises were raided, or they had, of course, the government had a warrant. They found electronic storage media, thumb drives, external drives, a personal computer. They found some product of BD. They found documents that were marked BD confidential. They found entrepreneurial type, one book that had to do with starting a business. They just found various property of BD, and they also found other interesting and possibly relevant information.
Now, the other interesting and possible relevant information, did that relate to his prior employer before he went to BD?
It's possible. I mean, it has been made public, and that he had also worked at Bard, and that he had he's pled guilty to another count of trade secret misappropriation, and that involved Bard, his work at Bard, years before coming to BD.
Sure, we have a question.
as a hypothetical, during this exit interview, if it were ruse or otherwise, if he had admitted he had borrowed the materials and disgorged himself and returned it to you, was there an understanding either on your part or with the FBI or the prosecutor's office as to what the ramifications would be?
Let me just repeat that for the people on WebEx. The question is, if this individual had come in and basically bared his soul and admitted that he took it and turned it over at that point, what would have happened?
I would imagine the outcome would have been different. I can't. I think it would. I mean, we, in earnest, wanted to know where our information is, what he had done with it, and if we were and if we were convinced that we had all the information and we were convinced that it had not been disseminated, then I could say from BG's perspective, it would not have been a matter.
Let me ask RJ, you were an former assistant U.S. attorney. I mean, what would you, from the United States Attorney's perspective, what would have happened here?
It would have been different because, well, a couple things. Let me back up a second. There's a lot of work that BD did that interested the government in this case. Without that groundwork, we wouldn't have been happy. But to answer your question, once the government is involved in it, it's no longer BD's decision as to what happens. Okay, that's number one. Two, attempt is just as severe as actually doing it. Conspiring with others is just as severe. At that point, given the national interest that would be involved, again, depending on the value of the trade secret at issue, the fact that it's a foreign national that's doing it, that's taking U.S. Research and development information to a foreign country, those governmental interests would be strong. And in those circumstances, whether BD was happy and satisfied, it would be of no moment to a prosecutor in that. But let me back up a second. What caused the government to accept this case, as Nick was a former prosecutor, as I was, our workload was very heavy, extremely heavy, with very serious matters. And we would have a stack this high of what we'd get into. So when somebody comes in from the street from saying, hey, I have a problem, that problem has to be well defined. It has to be very well defined, organized, and presented such that I can take a look at it within the hour and make a determination of, yes, this is serious enough that I can contact my friends at the Bureau and say, folks, this is something that we need to move on, and we can move on quickly. But that requires going back to the beginning, and Mark can talk more about this, trade secret audits. We know about our patents, we know about our copyrights, we know about our trademarks, but we generally neglect our trade secrets. And sometimes the most valuable information that a company has is its trade secrets. Because with patents, after 17 years, it's disclosed. Everybody knows about it. Trade secrets like a Coca-Cola formula, KFC recipes, things of that nature, paint formulas. In Exhibit 8 of the material you have is a case that I put together for Valspar involving very similar facts to this case, involving paint formulas which have tremendous value to them. So one thing you do is trade secret audits in terms of identifying what you have. You have code of ethics, and we'll get into that later. You have certifications, you have training, you have invention, you have assignments, you have electronic mail and computer access procedures and policies in place. You have IDs, you have keywords, key passes. A lot of things go into building what he shows up.
Which we'll get into in a little bit
more detail. But when he shows up with that package, it's all there ready to go. So a lot of the work and a lot of the reason for this prosecution is to the credit of BD and Mark and others who worked on that. But to answer your case, absolutely. Once the government is involved, it's no longer a personal matter. It becomes a matter of public interest.
So Mark, what happened after? I mean, they raided his hotel room. Mm-hmm. I assume he was arrested. Am I correct?
Not immediately. So on that Monday evening, they did go to his hotel. They did find all these materials, and then by Wednesday evening, they had then gone back to his premises and where he was staying, and they did catch up with him, and they arrested him, and he's been in jail since, and to date.
And he recently pled guilty?
He's recently pled guilty on 2 counts of trade secret misappropriation and attempted trade secret misappropriation.
And just so everyone knows, that criminal information is under tab 7 in the materials today. The reason it was an information was because he decided to plead guilty. Normally there's an indictment that has to be returned by a grand jury. Under the U.S. Constitution, you have the right to be indicted by grand jury, he obviously decided that it was in his interest, because of the overwhelming evidence that they had gathered, that he would plead guilty and try and get the best deal he could.
And in September is when the sentencing will take place.
So there still has not been a sentencing.
This might be in the presentation, so I'll wait. But you mean the data can't walk? So how did you know it didn't leave that hotel room?
Well, that is actually a good question. The question is,
One related to that.
okay,
You can answer at the same time. How did you initially discover that he had copied these files?
okay. So there's two questions here. One, how did you discover that this individual had copied the files and downloaded them? And secondly, how have you satisfied yourself that he didn't take these, send them to a friend in India by simply emailing them, or putting them on another drive that he gave to somebody else?
So to answer the first question, I think that's a little bit more known. The second one, to answer the second question first, how do we know? We don't know for sure. We're quite confident because of the speed in which we worked, because he had just moved out of his home, had just moved into an extended stay, had no reason to believe that this was detected. And there's been no, and the FBI, I know, has really done a lot of diagnostics to see. We have not seen this, but look at his personal emails, and there's a lot of confidence that it's not gone anywhere. Do I know for 100% certain, with 100% certainty? No. That's to answer that question. How did we know? Well, so this has been an evolution for us as well, and we continue to evolve here at BD. I would have said a year or two before that, we either would not have known about it, or we would not have had enough of a record keeping to bring to the U.S. government, or to move forward. So we have, without going into too much detail, I mean, we do have generally there are two types of activities that we look at. I touched upon that already. We are looking at all associates to see, and this is in our policies and it's well known, if an associate at BD is sending emails to a personal account, and they're doing it from BD, we will see that, and there's sometimes many good reasons for doing that, and sometimes there's not. And if it's not a good reason, we will know about that. We don't want that we don't want IT to do anything with that information if there's a good reason. If somebody's just casually looking at their email, our policy does say that we understand that minimal use of the internet, to look at the news, to maybe check your personal email, is something that's normal. But of course, downloading BD documents and sending them, emailing them to yourselves is not. And then we also look, and this we can't do with 28,000 associates throughout the world, either for foreign law reasons and or just because of the volume of information and the number of people. So we look at activities for various groups of associates. We don't look at any individual unless there's a reason that we have a reason to suspect that. The project team that he worked on, that project was a very high revenue, very high growth project. We had departures in the past. We've had at least two events where one time a number of associates departed, and we just sensed that maybe something worked out. We had no idea. The second time, we know materials were downloaded. We actually took some action in that case as well. Not as highly, not high profile, but we took action. And but our systems have evolved to detect and to look at activities of certain associates based on what we believe is the right place to focus on.
Okay, let me ask you this, Ed Stroz. You were with the FBI. You're now kind of going after these hackers as a private individual. Is this an unusual situation?
It really isn't. In fact, it's become so common. Our British office and my British colleagues have a term called bad leavers, and they mean somebody who leaves the employment of a company under bad terms. And we've sort of come to really like that term, and we call them bad leaver cases. We probably are opening, I don't know, probably 5 to 10 bad leaver cases every month or two. They happen quite a bit. And
they invoke a lot of questions. I think this is a terrific case study, and I really am glad that we can cite the examples here. There are different versions. They don't all happen exactly this way, but it's quite common. Sometimes the evidence is very clear, and you know what occurred. Other times there's a suspicion. They just don't feel comfortable about the way this occurred, and it's a question, as you've heard from people in the audience asking, how do you even know what happened? Is your suspicion backed up by facts? Can you get to the truth of what occurred? Or is it sometimes even just doing an investigation to get the comfort that it didn't occur is worthwhile? But we see quite a bit of this.
But how about the question that was asked by a member of the audience that, look, the FBI, they came in, they got the hard drives, this guy downloaded a lot of material over a long period of time. Yet how do we know that this material never made it outside, that somebody else didn't receive it, and that there isn't somebody in some little shop somewhere who's, getting ready to compete with, BD?
I don't think you ever get complete assurance on that. For two reasons. One, there could have been an independent download action aside from anything that you get, and you're not going to find that there. Secondly, even if the only download action that occurred is the one that put the data on the drive that you seized, there's only limited assurance you can get that that wasn't copied. Now, there are some things you can do to sort of narrow down the unknowns a bit, but you're never really in a position where you know what occurred. So,
there are certain cases where certain agencies of the federal government will help you. The NSA has that with its budget anyway, and it's
well, if there was a well, I think one of the questions was whether there are agencies in the government that can help you with this. Maybe you could address that a little bit, Ed, because, that does come up. We're now finding the FBI is coming to private companies at times, and they're trying to involve private companies. Maybe you could speak to that a little bit.
Sure. So the point is, there are technological horsepower that you can bring to bear to try to answer these questions, and that is true. But it never really leads to the complete understanding of what happened. And for this reason, even if you bring the NSA a drive, or you get to the level of not just analyzing data but analyzing physics with sort of mechanical residue on the surface of a platter, no matter how much you analyze that, you don't know if there was an independent action having something to do with nothing you were ever presented. And for some of our clients, we've actually had to go into other countries with the consent of the company that is under suspicion to just try to get, but it was always a matter where we weren't going to come back with complete assurance, just better assurance, and to show people how seriously we take this and that we could sort of compare what we were finding to what they were telling us. Because sometimes the information that you find also contradicts a representation that you got about things. So there's a lot of good information that comes from here. I would say trying to get the horsepower, the most heavy-duty horsepower aligned to analyze a given hard drive is a little bit like trying to get an aircraft carrier to deal with, a local robbery. We have it, but to get it in place is kind of difficult.
The federal government has a very different perspective, as you know so well, being done by DHS and TSA can immediately put him on the no-fly zone. He doesn't go anywhere. And I used to be involved with you guys, and so will be U.S. CERT. And when U.S. CERT is involved, which monitors everything everywhere, you have immediate involvement to get additional resources and help you. Plus, you also, the EU has now got policies and processes in place to work with the U.S. government because of the issues of stuff. We are working very closely to try to change things in the Far East, which is important.
Okay, two comments. I have two questions. One, the NSA, because of the Snowden incident, has sort of changed its procedures, and there's more cooperation with the EU. Have you seen that, Ed, in your...
Yeah, to both questions, yes. Also, realize, I don't want to get too philosophical here, but before 9/11, there were a lot of restrictions about, moving data. Now, some of that was bureaucratic and not very helpful. Some of it was there for good reason. And in order to connect dots more and bring down barriers and try to get people working, a lot of stuff that would have been done differently before was now sort of sped up. That made it easier for Snowden to perform actions.
Certainly this particular case does show, does it not? Kind of the global nature of the problem, in the sense that you've got a guy who's from India who's on his way back, taking back all this data that he could then use over there, and the reach of the federal government doesn't quite go that far, does it?
No, it is global in nature. The insider risk is huge. You have to realize, in order for some of the IT people and even just employees who do research to do their work, they have to have access to things. And that same access that allows them to make sure your systems are running and you're getting the service you need puts them in a position very often where they can copy data. The trick about the theft of intellectual property that is so hard for people to wrap their heads around is that everything that is stolen is still there. There is no deprivation of property with when it's intellectual property, unlike money, which can't be copied, has to be transacted with a debit and credit.
Although some people do try that.
Yeah, some people do try. I'd rather fight that crime. So you're right. And then the overseas issues, the FBI is not everywhere, and even where it has offices, it's usually just in a legal attaché representation and can only really operate through the local authorities who have the law enforcement power.
We have another question. Sure.
Is there nothing we can do technologically to degrade the information that so it's unusable?
Okay, this is the question. Is there anything that we can do from a technological standpoint such that if somebody removes the information, downloads the information, it cannot be used? Other than encryption, I mean, is there anything that is out there that would really make it impossible? I mean, the idea being if someone takes it, well, it just turns to gobbledygook and they can't use it elsewhere.
Other than encryption, I have not come across anything. Now, you will see vendor pamphlets that claim to do quite a bit. I have not encountered anything that works that way, but I would say this. Keep in mind one thing. Computer code is basically the electronic execution of logic. If you can craft a decision tree that says that this file should be destroyed or not openable on another computer and basically build that into the logic, you could probably build software that would honor that logic and those instructions. I have yet to see anybody do it. And also, even where there is encryption and other things, most of the time, when there is a conflict between convenience and security, convenience wins. And today people are busy. They can't. They don't want to apply the encryption. They get frustrated if they're forced to. The executives scream at the IT guys, "Why did you ever give me this?" And so I think even where we have solutions that are effective, very often the drag that they bring becomes a bit of a problem. Now I think, and it looks like there's another comment here, but I've been very impressed with what BD has done in this area, and is sort of really look to take a close look at what can be done and try to take as much drag off of it. But it really requires, in my view, that you have almost a government-level implementation coming down from the top rather than asking middle management to get this secure and make sure it's not inconvenient.
Right. And that question and your response in our case enlightens us on the fact that BD has gotten much better at seeing information that's gone out the door and responding very quickly to that. But I think the question suggests, how do you stop it from going out the door in the first place? And that's very difficult. One thing that we are right now, it's been debated quite a bit, is do we shut down all those USB ports on the computer? Do we make them only so that you can upload information but you can't download? Now you can download by getting permission from your manager in IT, because I need to download 20 documents and send it to my lawyers. There's ways to get around that, but it entails an inconvenience to the day-to-day user. And of course, they're like, why is IT making this so difficult for us? On the one hand, on the other hand, if we don't do something like that, it makes it easy for information to go out. And as I said, one more, and that is, anytime somebody goes to certain websites, including Yahoo Mail or Google, it says you are going to a site that might be unauthorized, and it's a huge warning, and it's like red, and it's almost obscene, warning you, and it's something you can't go there. If you click through that, I guess, but it shows that BD is watching. So there are deterrents, and there might even be some physical things that you can do, but that's the challenge: is how do you prevent it from going out in the first place? And
I think the criticality for your firm, given the fact that medical devices of all kinds, from pacemakers to what have you, can be literally hacked. You guys literally, significantly improve and look at both policies and procedures and how you manage all
Yeah, I think the question is that Becton is particularly vulnerable because of the medical device area. I mean, is that a fair statement?
I agree. And of course, obviously, there's safety issues, but you could say the same thing about an automobile manufacturer. There are those safety considerations there. And then, of course, there's no safety considerations necessarily with a financial institutions, but there's certainly a lot of, interest, for the citizens of this country and those around the world. But yes, I agree. I mean,
Bob, you had a...
Yeah, on that point, and I hate to be a naysayer, but it's going to get worse. As many of you that work with financial institutions know, the Office of Comptroller of Currency has just issued some guidelines for third-party vendor risk management that all law firms will have to comply with, and then their downstream third-party vendors will have to comply with. It's a tsunami. People are going to be screaming, but it is inevitable, and our lives are going to be, the convenience factor is about to go out the window now. There's a lot of smart people that can, I think, help us, but I think encryption is just going to happen. It just is. We hate it. It's going to be...
But there's ways that you won't even know it's there.
I think there'll be a way to make it more seamless, but I think we're going to see a game changer. We're already seeing it. By what is happening in the financial institutions, and because of the vendor relationships, and then under sort of the new NIST standards, what's best practices, you're going to see most major companies doing it and demanding it of their vendors, and that supply chain gets to everybody. It's not 6 degrees of separation, it's about 2.5. We're all going to have to do it, and it's not going to be tomorrow, but we won't be having this discussion in 2 years.
RJ, you had a point to make?
Two points that I wanted to make. One, we're dealing external threats are different than internal threats. External threats, you could use encryption, you could put firewalls, you could do a lot of things to slow that down. But there's no technology that exists that will prevent a trusted insider from stealing the crown jewels. That will always be a problem. In our case, it was a research scientist who had the pain for it, who had the authority to get on there. And Nick will get into exceeding authority and things of that nature later in our presentation. But there's nothing you could do. You cannot degrade the data. You cannot block USB ports. You cannot do that when it's your own research scientist that's stealing the stuff, the person who's been entrusted with the crown.
Another question.
So you mentioned the OCC guidelines and other governments that require more security, but they're vendors. My practice is mostly focused on negotiating technology agreements and technology services. And overwhelmingly, certainly the largest and most used, require you to sign contracts that effectively disclaim all or nearly all liability for resources. And they do it in various ways. They have consequential damages, limits on dollar caps, they have disclaimers of types of warranties, they say specifically about the risks, and they're, even for a customer who's fairly large, they're almost impossible to negotiate. Trying to negotiate with Amazon, the lost cause. So, how do you see that those contracts interacting with the government?
Yeah.
So the question is this, that negotiating contracts, normally a company like Amazon that has lots of bargaining power, is really going to look to avoid any kind of liability in this area with data being stolen. And I think the question is, where do we see that going? Bob, you were going to respond?
Go ahead first, then I'll...
Well, certainly I see that too. I do a lot of negotiation of contracts. I mean, if Amazon, or by virtue of its employee, for example, if there's some willful misconduct or there's some really bad acts going on, I don't think they're going to be able to stand behind those contract provisions. But otherwise, you're right. I mean, it's difficult. And I think the government does want to see that you're taking reasonable actions to protect your intellectual property, your trade secrets, in order to get their support. And I think having those agreements in place do something, even if there are limitations. And again, if somebody goes well beyond what they're supposed to be doing, I would posture that those provisions it's going to be very hard to stand behind those contract provisions.
And let me just add, if I could, to that. It's a two parts. One is, what level of security are you going to have to certify, essentially? There's going to be certification requirements in some form. That is one dimension. The other dimension, what's the risk shifting involved? That's a different issue, And that's a question, I think, of negotiating power. But the Amazons of the world are still going to have to say, we have a secure platform, and we will certify that. That doesn't mean it's fail-safe, but I think that the supply chain issue will get to everybody. So then it's the question of what's the risk shifting within that group of people, but you're still going to have to step up to the plate and say, we have a secure platform. I'm sorry that there was a question.
Point, just choose your partner as well. I mean, Amazon, at least, a very reputable company. If another company does not give you that same sense of assurance, don't work with that company, maybe, if you have that luxury.
Okay, we'll take one more question, then we're going to move on to kind of the legal ramifications. Go ahead.
The less interesting stuff. No.
I don't understand why the person after his temporary residence was, raided by the FBI. Why he didn't pick up and leave? Why did he wait to be arrested?
Okay, here's the question. Apparently on a Monday, his hotel room was raided. They took out all of his hard drives, and he wasn't arrested till Wednesday. And the question is, why didn't he just pick up and get on a plane and leave at that point?
So a couple of things. One is, I don't know if they took his passport or not. That would make it tougher to get out of the country, maybe impossible. Two, I believe his name was put on some list that would have made it difficult for him to leave. But I don't know what he knew, and probably I don't know specifically why he did or did not do what he did. I will say this because this was in one of the local press reports. When they went to the hotel where they found the materials and they found him and his family on Monday. When they went back there on Wednesday, he was not there. And finally, with some phone calls with family members, he identified where he was. So he was trying to do something to stay away, but
it didn't work.
Right.
It didn't work. Okay, let's look at what actually, ultimately, he pled guilty to the Economic Espionage Act, which is the Federal Trade Secrets Act, which makes it a crime to steal trade secrets. And prior to going to the government, Becton filed a complaint that had within it a breach of contract, and I assume this was over his agreement with the company, am I right?
Yes. So
right, and you had misappropriation of trade secrets, which is a state cause of action, and breach of duty of loyalty, which is also a state court cause of action, implied covenant of fair dealing and conversion. And I noticed within this, certainly economic espionage and trade secrets is certainly in here. But I guess my question was the computer crime statute, the Computer Fraud and Abuse Act, that was not brought into the picture. Do you know why that was?
We had to move quickly. We made a decision that going to the New Jersey Chancery Court was the right thing for us to do because we got the sense that, first of all, state courts don't see this type of matters too often. So we knew we'd get the attention of the court. Didn't know if and this court is set up to have these emergency type hearings. They're set up to provide injunctive relief, and it looks like we got it right. Even though we ultimately we did get a permanent injunction, but again, all that wound up becoming the tail when the dog, of course, was the criminal action. But that's why we went down the path we did, and I don't know whether how much we considered either the Economic Espionage Act or the other act that you...
Well, the Economic Espionage Act doesn't have a civil component to it.
There you go.
The Computer Fraud and Abuse Act, though, which is a federal computer crime statute, does, and it can also be used in state court.
Okay. I don't know why we didn't. So.
Right, but this was not something, I take it, that was on anybody's radar screen at the time.
Right.
And I think what I'd like to do is just kind of take you through the Computer Fraud and Abuse Act, because I think, again, as this case sort of illustrates, this is a self-help remedy that is available to companies that I don't think a lot of people know about. It really hasn't it's gotten some publicity, but it's not something that's really on the radar screen. And let me just take you through kind of the basics of that, so that, did you have?
No.
Okay. Let me just take you through the basics on this. It really is the computer crime statute, the federal computer crime statute. It's in Title 18, which is the federal criminal statute. It was enacted back in 1984, really as a crime with respect to national security data and banking. It really was a point in time, 1984. I think most of us didn't even own PCs at that point. And certainly this theft of computer data hadn't really become a huge issue at that point. In 1994, Congress amended the Computer Fraud and Abuse Act to include within it a civil remedy, such that if you have been victimized, whether it's individually or as a company, were victimized by a violation of that statute, you would have the right to go into federal court and seek damages and injunctive relief. It applied to all computers used in interstate commerce, which just is about every kind of computer you can think of, because everything now connects to interstate commerce. It's been amended in 2001, 2008. It now relates to computers used in foreign countries, such that if somebody breaks into a computer in Beijing and steals data from there, if that computer does business with the United States and deals in interstate commerce, or simply as much as emailing into the United States, there is jurisdiction to go into a federal court. And as I said before, it really provides for damages and injunction. And in my experience, the injunction is really the key piece, because it gives you the ability to immediately go into court. Just as Mark was saying, this allows you to go into federal court, although you can bring this into state court as well. And there are advantages sometimes to going into state court as opposed to federal court. For the most part, I would say the advantages probably lie with the federal court because you've got better judges. You get quicker action, but that's not always true. I mean, just as Mark explained before, sometimes it's a lot easier to get a TRO in state court. You don't have to go through the notification procedures. They aren't as strict, although in a case that you mentioned, it would seem to me that you'd have a good basis with any judge to say, look, if we notify this character, he's going to flee the country. That ought to be a standard basis to keep somebody from having to give notice under those circumstances. The injunction here, though, is very important. I mean, I had a case in Virginia. In 24 hours, this particular individual got it just as he had done with the Becton situation, sent it to his personal email account. We had all of this in computer forensic data that we were able to put together. Went before Judge Payne in Virginia in federal district court, who lived up to his name in every sense of the word. He basically ordered the defendant to show up within 3 hours with all of the data, including his computers, including the data that was on his new employer's computer, and if he didn't, he would go to jail. So it's a pretty powerful statute, and in the right circumstances can be used by companies to protect themselves and to be, take the offensive here. It relates to stealing valuable computer data, schemes to defraud, trafficking in computer passwords or similar information, damaging computer data, hacking, extortion, a very common scheme now. I mean, you probably have seen this, Ed, where people are basically told, look, if you don't give us a certain amount of money, we're going to destroy your computer system or we're going to shut you down. I mean, that's probably something that you've seen more often than not, am I right?
It's happening a lot lately, it's a form of extortion, and very often the demand is for not that much money. And so just to be able to get going and put this behind you, people will give into it. And it's been out there for many years, but really, I'd say, has taken off this year.
Yeah, no, quite. Everything has sort of taken off this year, hasn't it? Yeah.
Well, there's one right now that is, you do not open attachments from people you don't, number one. And number two, it takes over your computer and extorts about $500 out of you as a charge card or in Bitcoin. So.
Yeah, I think somebody in the audience just mentioned that there's a scheme now where basically it takes over your computer and it forces you to pay $500 or you're not going to be able to use your computer going forward. So
your computer, your phone, your tablet, and the only safeguard you have is if you have a password that they can't break.
Right. Or two-step identification is essentially one way around it. But anyway, the Computer Crime Statute, the Computer Fraud and Abuse Act, really does cover the whole area of computer crime with respect to computers. And the statute is pretty clear. It includes protected computers, which is defined by the statute, to really include all kinds of computers. I mean, it would include an iPhone. It would include even an iPad, an iPod. It doesn't really take much to fall within this definition. I think the only thing that's excluded is an electronic typewriter. So it's fairly broad. The key element in most parts of the statute relates to somebody who accesses the computer without authorization or exceeds their authorization, and I'll get into that in a moment. It relates to theft of information or anything of value. The damage to a computer system has to be permanent. There are a lot of cases out there where you have disgruntled IT people who leave, wind up destroying the computer system, and the government has brought cases against those people. A key element that I'll also get into a little bit more is that you have to show $5,000 in loss as a jurisdictional element just to get to the point of bringing a case. And I'll talk about that in a moment. It only relates to economic damages. As much as many of us have suffered pain and suffering as a result of our computers, that doesn't count. It has to be real economic damage, dollars and cents, and compensatory damages. There's this 2-year statute of limitations, but again, if it's something you discover later on, that statute is told. But I think the real value in this statute is being able to come across an incident, just as Mark had mentioned, where you really find something that's an ongoing situation where you can run into federal court and get an injunction and put a stop to it. Now, that doesn't mean at the same time you don't go to law enforcement, and we'll talk about that in a moment, but it definitely is one of the elements out there, something in your toolkit that can be used. You going to say something, RJ?
Very briefly, Nick, one of the reasons that people don't use the Computer Fraud and Abuse Act is because you can't get lost profits on it. It's a thing that you use as a tool, as one of a number of multi-pronged tools. When you have a theft, you need to use a lot of tools in your toolbox. If you need an injunction immediately, the Computer Fraud and Abuse Act is great there. Another problem with the Computer Fraud and Abuse Act is this exceeding authority. It doesn't necessarily deal with a trusted insider who decides to steal the crown jewels. There's issues as with respect to...
I'm going to get to that in a moment, because we're going to talk about that. In two circuits in the United States, there is an issue there that has to do with insiders. But let me just talk about this $5,000 jurisdictional limit, which is actually, if you have to take one basis upon which most of the civil actions are dismissed around the country, this is it. There is sort of a distinction here between your actual compensatory damage and this $5,000 jurisdictional limit, which a lot of people just do not understand, and I think we should dwell on it for a moment. Loss is defined by the statute, and it essentially is just as you see on the slide here, that during any 1-year period aggregating at least $5,000, loss is any reasonable cost to any victim, including the cost of responding to an offense, conducting a damage assessment, and restoring the data, program, system, or information to its condition prior to the offense, and any revenue lost, cost incurred, or other consequential damages incurred because of interruption of service. So this is just to be able to have federal jurisdiction. Congress put this in presumably as a way to sort of sift out cases that really didn't rise to a particular level. Now, whether that does this or not, it's hard to say, but it certainly has led to the dismissal of a lot of cases. Now, what is it that can be included under this $5,000 loss? Well, one is the cost of investigation, and correct me if I'm wrong, Ed, but there is no investigation that you conduct that costs any less than $5,000, yes or no?
You're right. We're always trying to help the victim.
So, I mean, bringing in a forensic firm just automatically gives you that $5,000. The other way you can do this, which the Ninth Circuit and some other courts have passed on, is that using your own internal people can also be a way of you doing that. If you've got internal forensic people, what you wind up doing is then taking their kind of what their hourly rate is based on their annual salary and putting that into an affidavit before you go into court. The other piece of this that really people don't understand is it's got to relate to the computers, this $5,000. The leading case is here in the Southern District of New York, this Nexon case that was before Judge Cederbaum, and it related to a German company that had some insiders who took data, and the officers of the company who were located in Germany flew over from Germany to the U.S. They looked at the computers. I think they took 2 trips to do that. They had a great dinner at La Cirque, all of which amounted to about $8,000, and they tried to claim that that was their loss. Well, needless to say, Judge Cedarbaum found that no, this could not be considered loss under this statute. It has to relate to the computers, and a dinner at La Cirque just didn't cut it. So it's very important that you look at this and in terms of having the right items that cover what is loss. The other part of, and as I said, the responding to a defense, this is the case in the Ninth Circuit, the Middleton case, where you can actually, they say you can use internal people to do this. But the lost revenue is also another area that's not really understood. You cannot use, for example, in the case with Becton, where you had trade secrets. I mean, clearly, from that, you could say that there was huge losses in terms of what you spent, in terms of what the revenue would have been. Am I right? I mean, do you ever categorize that?
I mean, so as far as the information, the value of the information is very hard, but that's a potential loss depending on whether it was disseminated or not. Certainly, we had internal associates that did a lot of investigation, and both on the IT side as well as in the business. I don't know if this would count, Nick. Of course, we engaged outside counsel. I don't know if that's considered. Is that considered?
There are some cases where they've actually counted that, but I don't think that's going to count.
So,
I think there's other cases that say, look, you've got to. What you're paying for is not really sort of an investigation to bring a lawsuit, but it's really to sort of assess the overall damage and what you can do to repair the system. So I would say that the courts that have found, I mean, there's only a couple of courts that have done this, are wrong. But it is something that people throw in, it seems, every time they bring a case.
To answer your question, I mean, ultimately we did spend thousands of dollars internally to conduct an investigation as to what happened. It probably would have taken a number of weeks before the hourly rate of our internal folks, times the number of hours that they worked on this, would have amounted to $5,000.
Right. But I think the big point here is the lost revenue. It has to be because the business lost revenue because of an interruption of service. It can't be just because you had a trade secret that was stolen that would be worth a lot of money, and therefore you would lose X dollars in profits. Now, that could figure into your ultimate compensatory damages if you wound up taking this case straight through. But it certainly wouldn't relate to the jurisdictional amount. And this is a point that a lot of people just don't understand. Again, this Nexon's wires went up to the Second Circuit. This is after Judge Cedarbaum knocked out the La Cirque monies. And the plaintiff claimed that the theft of confidential information caused it to lose $10 million in profits. Well, those $10 million in profits don't count towards the loss in terms of the jurisdiction. Again, it has to relate to a loss of service, or service denial, and I think this is a very important point to remember if you're going to use this statute and you're going to draft a complaint and go into federal court. Go ahead.
I thought the thrust of this discussion was that this is a powerful statute, which I think we all recognize, but it is simply a predicate, and that it can be used in conjunction with other statutes in order to either expeditiously enter federal court or simply to act as on the strength of itself. Since this is a jurisdictional matter, isn't it just simply the allegation going to be sufficient subject to a defense claim that they don't have jurisdiction?
Not really. You've got to now plead with really details on this. Yeah, specificity. I mean, you really have to come up now, the way the federal courts are now, you've got to give specificity. You can't just say, we have a loss of $5,000. You've got to give some specificity as to where that comes from.
So you attach the contract from Stroz?
Oh, he's got one. You just it says 5,000 plus, not a problem.
BD playbook now.
But certainly that's an easy way to go. But you've got to be careful how you frame it, because you can't frame it as putting it together to bring a lawsuit. It has to be framed in terms of checking out your systems, making sure that you've looked at the problems, you've corrected the problems. That's really what what the statute is directed at. And there have been cases, even where you have the $5,000 loss, where the lawyers unfortunately framed it as an investigation to bring a lawsuit as opposed to an investigation to determine the scope of the issue, rectify the problem, and fix the computer system.
So your definition of loss, one of the clauses was responding to
an offense, right. So responding to an offense would be to respond to look at what happened to your computer system, fix it, and make sure it doesn't happen again, and figure out where the holes are in your system. So that would be responding to an offense. It wouldn't be responding so you could file a lawsuit necessarily. Now, it turns out that the same work that you're doing to respond to that offense also happens to gather the evidence that you use for the lawsuit.
Well, and since confidentiality is often thought of as you hire your outside firm to provide that umbrella, which the outside firm then retains forensics.
Yeah, right.
It would seem that would be, once again, the predicate to justify the additional expense of, I'm giving you a softball to be I don't know how much more I can do.
Well, no, I mean, certainly, yes. I mean, it's pretty unusual when you bring in a forensic firm that you cannot use that $5,000 plus as part of your loss. It's very unusual not to be able to do that. You can't do that with the lawyer's time. You can't do that with what the lawyer's doing, but certainly you can do it with the forensic investigator. There's no question about that. I mean, that was decided very early on back in 2000 by the First Circuit. So that is clearly an easy way to go to make sure that you've made the $5,000.
You touched on something, you mentioned the response and making sure it doesn't happen again. If that involves purchasing additional software or changing some infrastructure, does that cost a pound?
Matt, it's a good question. A question was asked whether or not actually buying software to fix the system, to secure the system, whether that would count as part of the $5,000. Yes, it would. Absolutely would. So that is a good point. Another question.
If you really hire the forensics team, they'll go through $5,000 in about an hour.
Okay. The question was, I don't know if it was a question, but it was certainly a statement of fact, is that if you get a good forensic team, they will certainly go through $5,000 pretty quickly, and I think you can attest to that, Ed, right? I mean,
yes, it wouldn't be in an hour, but you just have to realize they're not fixing your computer. Just quickly, I don't want to get off topic too much, but you have to preserve every bit of data within the drive in a forensically sound way so that you have a logical way to show where your findings were sourced and that you didn't miss something. And when you take that approach, and then the data has to be loaded into forensic software that allows you to see things the user can't see and to be able to manipulate the data without changing it. And so in order to invest in how to use that, the software that goes with it, the protocols that are involved with executing it, it eats up time, and it's not a field for amateurs, I would say.
So let me look at what I said before about the key issue here is unauthorized access. Unauthorized access or exceeding authorized access is really the key element in about 4 out of the 7 potential causes of action under this statute. This particular one that I have up on the screen right now is just one of the 4. Whoever intentionally accesses a computer without authorization or exceeds authorized access and thereby obtains information from any protected computer essentially commits a crime. A felony, in some instances, it can be a misdemeanor. Again, this is really what you're left proving here is a criminal violation, the only difference being in the civil context, you prove it by a preponderance of the evidence. In the criminal context, it's obviously the government has to prove it beyond a reasonable doubt. Let me give you one example of a case. This is one I brought back in 2000. That's the EF Cultural case. And I think this gives you an idea of how broad this statute can be, what you can do with it. This was a civil case that was brought against some ex-employees that set up a competing student travel company. EF Cultural was a company that was involved in the student travel business. They would get high school teachers who would go out and recruit students to go on trips all over the world to all kinds of different locations. And of course, the key was that the high school teacher who did the recruiting got to go for free. And the ex-employees, they left, they set up a competing company, and in order to undercut their former employer, they had to come out with a catalog before the start of the school year. They left their employer sometime April and May, so they didn't have a lot of time to do it, and what they wanted to do was to basically undercut every single one of the prices that their former employer had, and there were some 150,000 plus permutations of different prices, with people leaving from different locations, going to different locations at different times of the year. And so this was not something that you could do manually. If you went on the EF Cultural website, any individual could have gotten a couple of prices at a time, but to actually get all that information and be able to use it and undercut it was not an easy thing to do. So what these ex-employees did was, over the course of the 4th of July weekend, they set up a robot, an automatic scraper, that because they knew how the URLs worked in all of the different permutations, they were able to set it up in an Excel spreadsheet so that over the course of 2 days, it downloaded every single price off of the EF Cultural website for every single 150,000 plus permutations. They then took all of those prices, massaged them a bit so that they were all undercutting the price of their former employer, and put those into a catalog that was then set out as a competing catalog to EF Cultural to the high school teachers prior to the start of the school year. Now, keep in mind that what they're downloading here is pricing data. It's not trade secrets. It's stuff that is out there in the public domain that anybody could have gotten any one of these prices with a few mouse clicks. And what we did is we went in, got an injunction, basically stopped them dead in their tracks from doing anything with this. And the First Circuit Court of Appeals upheld the injunction on the basis that their confidentiality agreement basically did not authorize them to download this information. That essentially they entered that computer knowing how the URLs were set up, how the topology was set up for all of the different prices, and upheld the injunction on that basis. Now, what they found was that the authorization or lack of authorization was established by the contract. They also found that the information under the other statute I showed you was valuable because they needed that information. One, it had to be accurate, and two, it had to be done very quickly. And if they had tried to do it using individuals just in a room trying to download everything, one, there was no guarantee it would be accurate, and two, there was so many different permutations, there was no guarantee that they would have gotten this in time to print out the catalog and be able to go and send this out to the teachers. So at the end of the day, I mean, what this case shows is that, one, you can use this with data that, you know, the Becton stuff was obviously trade secret information, but you can use it with data that is not a trade secret. You do not have to get into the elements of a trade secret that we're going to hear about in a moment from RJ, who's going to kind of take us through the Economic Espionage Act. And it also has the advantage that you can go into federal court, which can be a very valuable advantage as well. But this gives you an idea. I mean, it really kind of broadens the whole playing field here as to what you as owners of a company can do in terms of trying to take self-help and take action into your own hands. Now, of course, there are instances where this may not work. If you're dealing with people in foreign countries, it's kind of hard to bring a lawsuit and get people under the jurisdiction of a court in this country, but there are a lot of circumstances where this does work. And one of the important lessons I think to take away from this is what the First Circuit said is that the Computer Fraud and Abuse Act is primarily a statute imposing limits on access and enhancing control by information providers. Now, what's interesting here is it means that companies can really set the parameters of the scope of authorization or lack of authorization, whether it be for their inside employees in terms of what they can do with the computers or in terms of outsiders that go on to a public website. So this is almost like giving companies the right to put up no trespass signs at various points in terms of their computer. There aren't too many federal criminal statutes where companies really can set the predicate for the violation. Now, RJ is going to talk in a minute about the Economic Espionage Act, and there companies sort of have the obligation to take reasonable steps, which you're obligated to do under the civil part of the statute as well. But I think the lesson to be taken away from this is that there are proactive steps that you can take so that these laws can be used. And again, putting the scope of authorization into agreements, I think, is very important. This is something a lot of companies overlook, and it's very similar to kind of criminal trespass. Now, before we get into the trade secrets, let me just say there is one wrinkle to all of this right now in terms of where the federal courts stand. The Ninth Circuit and the Fourth Circuit. It started with the Ninth Circuit, which probably makes sense because all of these sort of crazy things emanate out of the Ninth Circuit, basically has taken the position that if you're an employee, you automatically are authorized to access the company computers. Even though you might be stealing the company's crown jewels, you're still authorized to access the computer, and therefore the Computer Fraud and Abuse Act doesn't apply. That view is taken only by the Ninth and Fourth Circuit. However, if you're doing business in those two areas, you've got to take that into account. And they've not yet really addressed the issue of whether or not, if you have very specific directions to people as to what their scope of authorization is in your rules or your agreements, whether or not that wouldn't change their view in terms of what they've ruled on this. But it does make a difference. Now, you've got the Seventh Circuit, Judge Posner, in the Citron case, where it basically has said that if an employee, at the point his employee's access to the computer is defined by his agency. And once that agency is broken by virtue of a breach of fiduciary duty where the employee does something at odds with his employer, namely go into the computer to steal data so that they can then go out and compete against you, authorization disappears. That view is really the prevailing view among the circuits right now, but there are a number of circuits, including the Second Circuit, that really have not spoken to this issue. There are a number of courts that in New York that will go on both sides of this issue. There are courts, even in Massachusetts, that will say that the EF Cultural doesn't really address the issue of former employees, since the individuals involved in that case were all ex-employees. So there is a bit of a minefield. The Supreme Court is obviously going to be the final arbiter on this issue. I think they're going to come out on kind of the side of reasonableness here, that will go with the majority of the circuits that are out there now. I think unauthorized access is a pretty common sense term, and that if you wind up going into a computer and stealing your employer's money or trade secrets, that's unauthorized access, and no employer is going to want to authorize any kind of access like that. But I think that's something that is an issue. It is an issue out there, and it's something you've got to be cognizant of in using this statute. And it can make a big difference in terms of where your violation is. I mean, New York State, I would say that, who knows where that's going to go. Yes?
I just want to make sure I understand the takeaway. So, under the case, the EF Cultural case, based on what you said before about the Computer Fraud and Abuse Act, it sounds like the act is a good way to get an injunction, but there's no real way to claim damages in a theft of trade secret or confidential information.
Well, no, you can claim damages. You can claim damages, but that's down the road. What I'm saying is, what you claim in terms of jurisdictional loss is different than what you're going to claim as compensatory damages.
How does that play into the sort of the Nexen Wires case, do you think?
Well, the Nexen Wires case, there was 2 points to it. One, they were trying to get into loss by virtue of dinner at La Cirque and 2 plane tickets. The court said, no, it has to relate to the computers. That has nothing to do in the end with compensatory damage. The other thing they said is that with respect to lost revenue, in terms of the $5,000 jurisdictional loss, it has to be revenue lost from a service going down, from your computers going down, from lack of service or not being able to use the computers because customers can't go onto your website, buy goods and services, and revenue lost from that activity would count as part of the loss. Now, it would also count as your compensatory damages in the end. But you really have to separate out the 2 concepts. One is this definition, a statutory definition of loss that is set by the statute itself. And secondly, compensatory damages, which comes after you get past the motion to dismiss and after you get past the motion for summary judgment, and you get to trial.
So in the cultural case, after you've met the jurisdictional requirement, which we talked about you could do by hiring a forensic firm, for example, that would go with.
Like Ed Stroz, exactly. Right.
Let's say you do that. Then you go and proceed to the injunction. Then you're saying, in the case like the culture, where the system wasn't damaged anyway, the website still operated, but confidential information was stolen, then you say you can claim that confidential information and recover damages under the Computer Fraud and Abuse?
Yes, after as part of your compensatory damages, but that's later. So the compensatory damages would be everything that you would normally go after under compensatory damages.
Well, let me push back on that. A trade secret is stolen, and my trade secret is worth hundreds of millions of dollars. Is that compensable under the Computer Fraud and Abuse?
If you can show that you've lost that amount of money, yes. Compensable at the day you go before a jury to argue damages.
Okay, but how do you reconcile that with the cases that say you're not entitled to lost profit?
Those are the cases that relate to the jurisdictional amount of $5,000. Those are the only cases that are out there.
Okay, if that's the case, then why aren't more trade secret cases being brought up in the Computer Fraud and Abuse Act?
They are, but the problem is a lot of them relate to employees, and there's this distinction now in the circuits which has caused a lot of employers to lay back. Now, if you're in the 7th Circuit, piece of cake, no problem. The 11th Circuit, no problem. 3rd Circuit, still an issue. 2nd Circuit, who knows? It almost went up in the 3rd Circuit, but the case was just dismissed for lack of venue a few weeks ago. The 5th Circuit, great circuit, not a problem. You can go for full bore there. It really depends where you are. And so before you bring a case, if you're a company that does business across the United States, you really have to look at where you are. And you may, if you have a choice of where you can bring the case, that can be important too, obviously.
I think that's a great point for where I want to start.
Okay, well, let me just talk to one other issue that came up in terms of other, one of the other causes of action that is mentioned under here is conversion. And up till about 5 years ago, New York State didn't permit conversion as a cause of action with respect to computer data. And this is still an issue in some jurisdictions. But one way to get around this whole issue about whether the Computer Fraud and Abuse Act applies in certain jurisdictions is to use the tort of conversion if it's permissible in that state. The New York Court of Appeals reversed what was a long-standing principle that conversion didn't apply to intangible property. And if you really want to read a very historical opinion that really goes back and looks at common law, the Thyroff case really goes back to 1066 and Norman Conquest and William the Conqueror, and sort of looks at the origins of conversion, starting with kind of the rule that the guy who stole the stuff gets his hands taken off, right up to trover and all these other kind of ancient causes of action up to conversion. The point being that the common law develops with societal norms, and the New York Court of Appeals decided that society had moved to such a point that computer data is so pervasive in our commercial life and our everyday life that there's no good reason why conversion shouldn't apply. So again, with conversion, you don't have this issue of the $5,000 jurisdictional limit. So but you have to bring it into state court unless you've got diversity jurisdiction or you've got some other federal cause of action you can bring into a federal case. So there's pluses and minuses to both. You've got to look at the place where you're bringing it and who the judges are, etc. But I think this all brings us into kind of the trade secret information that RJ is going to speak to. And RJ, why don't I turn it over to you? It's 10 o'clock, we'll go 15 minutes and we'll take a break. But let's talk about the Trade Secret Economic Espionage Act.
Before we get there, one of the key issues in any trade secret case is deciding where you want to go, how you're going to proceed, and how you. Sometimes, and the reason I raise that is that sometimes state court is the best avenue. I can tell you that in federal court in Minneapolis and Minnesota, ex parte TROs are not, no matter what the circumstance. Rule 65 allows them, Federal Rule 65 allows them, you're entitled to do that, but the judges there simply will not allow them. ex parte, TRO, period. That's something that you need to know in that specific. So you need to know specifically where the theft was taken. The fact that New Jersey has a chancery court tells you, there's still an equity law divide. And under equity, equitable remedies are available. The chancery court is a court of chancery, same as Cook County, Illinois. Cook County is a chancery court where you bring equitable remedies. Those courts are more likely to issue TROs, ex parte manner to proceed on those. With trade secret law, the problem you have in bringing a trade secret case is that a lot of the trade secret cases have the Uniform Trade Secrets Act. One of the first things the Uniform Trade Secrets Act does, it has a huge preemption clause. It says if you bring a misappropriation of trade secret case, you cannot bring any other common law cause of action unless it's based on contract. So there's a preemption provision that has to be taken into account that you have to deal with depending on which state that you're in. And then same with the Computer Fraud and Abuse Act, assuming you have the jurisdictional limits associated with that. In defense of the Ninth Circuit has held that with respect to employees, an employee who has authority to go on to the spreadsheet that contains the paint and has full authority to do that, the fact that they have authorization to do that and take that paint formula and then want to use it for their own purposes, they say that's not exceeding authority under the statute, because what they're afraid of is a slippery slope. At what point do you exceed authority? Because every employee accesses the internet to check their banking, to check the weather, to check the traffic, to do other things that are inconsequential. At which point does the firm set up a policy? You cannot do this. This is not access. And so once you do that, establish a level of access, then how could you, under the criminal law, go after somebody unless you have clear-cut, delineated parameters of to what is allowed access and what's not allowed access. So you get into a huge slippery slope problem. And that's what the Ninth Circuit was trying to address. And that the judge who wrote that opinion was Judge Kaczynski on that point, who said, no, look, this is what you're doing here. You cannot police it because you cannot stop it. Everybody knows that taking the paint formula out and doing that, that's one way. So it's kind of, but at what point do you stop it? Where do you stop it? So going back, so the first area of inquiry in all these trade secret cases, and the other thing is as Mark mentioned, you have to move very fast. These things are happening at a lightning speed. So if you are only thinking about your trade secret theft at the time that it happens, it's way too late. It's way too late because these things are occurring long before that. And you need to have your policies in place, you need to have your IT in place, you need to have your forensics in place, you need to have all the steps in line to proceed on where do you want to go. One of the things about the Economic Espionage Act, as I mentioned earlier, is that is a tool that only the government has right now. You can plead to them, you could do that. And I submit to you that the only way you're going to get the government interested to bring in one of these cases is to bring it in on a silver platter package with a bow tied onto it. Other than that, you're not going to get it. And it has to be significant. It has to be essentially near the crown jewels or involve a foreign actor or foreign government or entity of that nature for the government to be concerned about. Because the government's going to look at it and say, this is a dispute between two companies. It's really a civil matter. Leave it there. You need to get them interested that there is a substantial, compelling federal interest that needs to be set up immediately. And the only way you do that is when you walk in and you deliver everything from the beginning to end. So,
Sure.
Now, the Economic Espionage Act has two components. The first one is benefit of a foreign government, and the other one is misappropriation that will injure an owner. The benefit of the foreign government, it's interesting because when you deal with Chinese companies, most Chinese companies are state-owned. And so the fact that things are being stolen or misappropriated by Chinese companies, there's issues as to whether 1831 in and of itself applies. The definition of what a foreign government, it's not only the foreign government, foreign agent, foreign instrumentality, and beyond. And so the question becomes, what is a foreign entity for that purpose? That's issued to do that. Now we get to what a trade secret is. A trade secret basically is anything that gives you economic value that is not generally known or readily ascertainable, of which you took reasonable measures to keep the information secret. So let's go on.
RJ, this is the same definition, is it not, that is in the civil context too, right? I mean,
Absolutely. This is exactly pretty much mirrors the Uniform State Trade Secret Act. Absolutely right. The only difference that we're dealing about is the point you mentioned. There's a huge difference between beyond a reasonable doubt and preponderance.
Right.
And so that's, but it is the exact same definition.
But basically, the federal government, in enacting the Economic Espionage Act, has really adopted what the trade secret laws have been in all the different states.
Right, exactly. What's exciting about this is the Congress, for the first time in a bipartisan procedure, is thinking of implementing, adding a civil remedy to this statute, same as it did with the Computer Fraud and Abuse Act. And there's a likely chance that this might actually pass, making it a civil cause of action for the owner of the trade secret to seek redress for violations of these.
Correct me if I'm wrong, but right now, in order to get into federal court, you have to have diversity of citizenship or some other federal question to get into court with a state trade secret.
Right, with the trade, and the problem, again, this goes back to my point. The problem with state secret law is this preemption. This preemption knocks out all other common law causes of action except the misappropriation of trade secrets, and except contracts. There's always an exception for contracts. But under this one, you can bring those common laws. This specifically allows you to, there's no preemption clause to this. The Uniform Trade Secret Act has a preemption provision.
You're talking about the proposed bill that's
yes, the
Congress
proposed
now.
Yes, exactly. So the next step is that, next slide, is that whoever will intend to convert a trade secret related to a product or service, so it has to relate to a product or service, the next, used or intended for use in interstate commerce. The original version of this bill was used, and it didn't cover intended use, and somebody stole something from research and development, and because it wasn't used, it didn't fall under trade secret law. That was a Second Circuit decision that came out on that exact thing. So Congress went back, okay, what we really meant was use and intended use that covers it. So let's go back. To the economic benefit of anyone other than the owner thereof. And the law provides somebody, and this goes back to knowledge, and we'll get into that. You have to show that the person stealing it knows it's a trade secret. So your policies and procedures have to be in place that you tell them that when they first come in on the job. This is the trade secret. This is what they are. This is how we protect them. This is what we do that. Such that you know that. Such that when they take it, you satisfy the settlement. They're taking it to do something with it, to do an economic benefit for somebody other than you.
If I could jump in for a moment. At BD, we have a trade secret program where IP attorneys do go around the world, actually, to our manufacturing facilities and other facilities. And it's a four-prong activity. One, we educate our associates. We do an inventory of what we consider to be a trade secret. And then we make sure that it's being protected, and then we enforce when there's a need to enforce that.
Because that's an important point. That the inventory is the same thing as a trade secret audit. You got to know what you have. You got to clearly define what you have, and you got to teach everybody what you have and what you consider secret and private and that you need to protect. And then you go intending or knowing. Next one. That the offense will injure the owner of the trade secret. And now let's stop there, that the offense will injure the owner of the trade secret. One of the issues that comes up here, right, is what you have a joint development, okay? And you have two folks, the employee and the employer, and there's no clear cut as to who has the proprietary rights to this, right? Unless there's assignments, unless there's invention assignments as an employee, everything I create and have is automatically assigned to the company. If you do not clearly delineate that, then when the employee decides to leave, says, hey, I created that, part of it is mine, I could use what's here for my purposes and proceed with that. The offense will injure the owner of the trade secret. Well, if you think it's yours, right, if you think you're entitled to it, you think you're entitled to proceed with it, there's a couple issues that you have in terms of matter of proof. One of those issues, is it a trade secret? I didn't take the trade secret. It belongs to me. Secondly, I didn't injure. There was no injury caused to anybody because this belongs to me. So again, going back to your policy, knowingly steals without authorization, appropriates, takes, carries away. An interesting point that was made earlier by Ed is that what you have here, the thing is never destroyed. The loss is by the fact that it's taken and disclosed.
And particularly with data, right?
Yeah, exactly. That's exactly. It eviscerates the value of it. And what this here does is it doesn't matter, and this goes back to a point earlier, that no matter how good your encryption is, no matter how good your data is, if I was a very determined thief, I could sit at my computer and with a pencil put it up on the screen and write it out, because copies, duplicates, sketches, draws, downloads, there's a million ways to do that. If I do that, that's the elements of the offense. And then, so the reason we walk through this painstakingly is because we're going to go into how the things that you do as a company from beginning, going back to your code of ethics, going back to having policies in place with respect to electronic emails. How do you do electronic emails? When do you use it? The ownership of computers, the ownership of the phones, privacy right issues of warnings to others as to who this stuff belongs to, things of that nature, training to the people, what is a trade secret, what you're supposed to do, how to do certification. All those things come into play. Because if you walk through the Becton Dickinson TRO complaint and you compare it to the criminal complaint, you'll see that it talks about codes, it talks about things that the company did in advance. Same thing if you look at tab 8 of the Valspar case I talked about, where research scientists stole the paint formulas and was heading off to China. Again, as you walk through that, you'll see a whole sorts of things that the companies did in advance to do that. And as I mentioned earlier, the next slide, Nick, was that attempts are just same penalties apply. The only difference is that it's a substantial step. And a substantial step is doing something to try to make it happen. And what's interesting about attempts, you could be completely wrong about whether it's a trade secret or not. Okay? It's an attempt. And so that's...
So he steals the wrong file.
Yes.
Not only does he not get the right file, but he goes...
Exactly. for the big file.
Right.
Exactly. And then conspiracy, again, it's the same penalties apply to that. Conspiracy is an agreement to steal a trade secret, and further into the conspiracy. And you do not need to go beyond that. Well, frankly, it'd be interesting to hear a little more from Mark and Ed about programs that are available, because there was a question asked earlier by the audience. How do you go about detecting this? And how do you monitor these things? And how far can you go with the monitoring without starting to get into some serious privacy issues and things of that nature? So that'll be interesting to do that. But the point I'm making here is that maybe through your monitoring, you develop enough to show that there is a conspiracy and that an overt act was taken long before anything happened. And if you're able to package that, put it on a platter with a bow tie on it and take it into the office, you may be able to prevent things way in advance. Another comment that was made earlier is, how do you know it wasn't taken, right? And if on the civil side, if the civil remedy is enacted, there's going to be seizure provisions. And the seizure provisions here are broad.
This is in the proposed law?
Right, in the proposed law. The seizure provisions will allow you not only to go after the computer, but any other computer account, wherever it may be, that may have been used to do this. Which goes to your point, how do I know it was stolen? With Maniar, what I would have done, said, okay, the seizure should include his cell phone, the seizure should include his Google account, it should include his Yahoo account, it should include his cloud account, it should include everything that is connected to him electronically to allow me to be able to see, has my trade secret been disseminated to where else. Right now, the only way to do that is in state court.
Okay. And in the BD case, we did consider serving a subpoena on Google and on Yahoo. While we weren't told directly, we had reason to believe that the government was taking that sort of activities, and therefore we didn't go that far.
Okay, I think it's 10:15. I promised everybody a break. We want to take one question before we...
Yeah, it's just, is there another way to find out if the person has sold it? Can financial records be brought in on the civil side and analyzed to determine whether he was paying?
The question is whether or not you can get financial records to determine whether somebody has actually sold the trade secret. For example, bank records showing unusual amounts of cash going into somebody's account. In order to do that on the civil side, you would have to have a civil case in place and be able to use subpoena power. So the answer is yes, you can get that in discovery in a civil case, but you do have to have a civil case in place to do that. So why don't we come back, there's one other piece of this trade secret that I think is important that has to do with reasonable steps. That's one of the elements of the Economic Espionage Act. We'll talk about that. We'll move into the areas of personal data, and then talk about the different options that you have in order to protect your data. So stay tuned. We'll be back at 10:30 on the dot. Thanks. Okay, we've got a lot of area to cover, so I really want to keep this on schedule as much as possible. RJ, when we left off, we were talking about the Economic Espionage Act, the fact that the elements are pretty much the same as the civil and the criminal. And certainly one of the elements that's really important here, is it not the reasonable steps that a company takes to protect their information? I mean, that's an element both on the civil and criminal side. Am I right?
No, you're absolutely right. And I would also argue that it's probably the most important element. I think a lot of times why those cases is not brought by prosecutors is because of the reasonable measures to protect the trade secret. And sometimes, like for instance, you could take all the steps in the world to protect your trade secret, but you may disclose them in a public setting at some point. That completely negates what you're doing.
Because it's no longer secret. Right?
Exactly. You did not take, if this was a trade secret, what did you do to protect it? If this thing was really valuable, what steps did you take? Did you have employee ID cards? Did you have key cards? Did you have passwords? Did you have agreements in place, et cetera, et cetera, et cetera? We'll get more detail.
Yeah, no, Ed, whenever I talk to FBI agents, I mean, I talk about the Economic Espionage Act to try and get them interested in it on behalf of the client, and the first thing they say to me is, boy, this reasonable step stuff, which we have no control over, if your client didn't do that, we're out of luck, and we're not going to get the U.S. Attorney's Office interested in it. I mean, what was your experience as an FBI agent? I mean, was this an issue that you guys had to deal with?
Yes, it was, and I think it's more so now. I think RJ, just described it very well. If this is the standard you were going to be held to, then I think you have to step back and say, if we were to find that a trade secret was violated, how are we going to answer the question about reasonable steps and what we're taking? And I think what you do and can do today is going to be different from what I saw back in the days that I was at the FBI. And I actually did see a very significant trade secrets case actually that was a real close call in terms of being brought, was not brought for the exact reason that RJ was talking about, which is that it was a media company and they did have trade secrets, but basically they'd elected to allow in certain select locations, and I think there are only 3 in the world, for people to come and see certain things and experience it without being subscribers to their service. And that fact in and of itself undermined the ability of the government to feel that they could make the case, because this was going to be a very well-heeled defense effort on the other side, and this was going to be new ground, and they just felt that, and I think what was striking about it is that the decision by the company, the victim, to place these sort of selected locations and offer their service at these locations, it was never reconciled from a marketing action back to see what did it do to your security and your legal redress. So I had seen that, firsthand back when the law was very new. As I was leaving, I left the FBI in 2000. It was becoming increasingly important because it's an element of the violation. And it actually requires, so the U.S. Attorney's Office will expect the FBI agents to answer this question. What did the victim do to protect? And that can really beg a lot of questions about what is a set of reasonable steps, and do they really work the way they're supposed to? And it is very different company by company. So I would say in order to be, I would say, a good client, good victim in this area, yeah, I mean, it seems kind of perverse. But I think this kind of education and the kind of guidance that you're getting would allow a company to go back and say, if we expect to be protected or seek any kind of justice under the statute, and we know that we're going to be asked by this by the FBI or anybody else as to what steps did we take to protect, you really want to know what your answers are. And I would say they don't have to be, I think most, I can't speak for the FBI, but I would say when I was certainly in the job, you can deal with imperfections a lot better. You can go forward and say, look, we'll talk to the prosecutors, it's their call. You can't really overcome a defect. And there's a difference between an imperfection and a defect in taking reasonable steps. And that was a sort of an internal standard that I used. And you hope that the court rulings that come out will also help sharpen your guidance.
Now, Mark, you obviously had to marshal what the reasonable steps were before you went in on the civil case, and I assume this was asked of you by the FBI, right? I mean, maybe kind of give us an idea of what you had in place at the time and what you've done since. I mean, obviously you learned some things from this incident that sort of sharpened your ability to come up with reasonable steps here.
Yeah, and certainly I'll answer that. And to echo what Ed just said in terms of being a good victim, I think the U.S. Attorney's Office and the FBI want to see that you do have the measures in place that substantiate the elements of what you're trying to hope that they're going to achieve for you. But you also want to be cooperative. I got the sense that they also appreciated the fact that any time that the FBI or the U.S. Attorney's Office contacted us, we got back to them within 15 minutes, half an hour, or the next day if that was reasonable if we had to research something. I think part of the reason why the government was so cooperative, so helpful in our case, was because we were also helping them help us. So, but to answer your question now more specifically, we at BD have a lot of processes in place that I think you take for granted if you have them in place, and if you don't have them in place, it's almost like wearing a seatbelt. I think a lot of us just put it on, don't even think about it, and there's a very high likelihood that you're not going to get into an accident. But man, if you do get into one, it's great that you had that on, right? And I think that's how we felt after the fact. I mean, of course, everybody has badges to get into the building. We have swipe a badge to get into our buildings. Anytime somebody wants to get into one of our plants, the same thing. To get into the security systems, the computer systems at our company, like probably most of your companies, you have to type in a password. The passwords need to be changed. And they ask questions about all these things. Again, we have banners explaining to associates that they're entering BD's systems. We have a trade secret policy that I talked about already, where we do an inventory, where we first train, where we protect and ensure that there's protections in place, and where we enforce. We have a code of conduct. We have ongoing training, be it electronic training or live training. I mean, these are all the things that we had in place, and it was actually refreshing when the government asked, when the FBI and the U.S. Attorney's Office asked these questions, that we were able to kind of rattle all these things off. Had we not had most of these things in place, I think they might have been nervous that a judge was going to say he did not do what it needed to do to have this information characterized as a trade secret or inform its associates that they were dealing with trade secrets.
But let's say after this event, I mean, did you kind of change those and even add on to those? What you would now? I mean, if someone came to you now, the FBI came to you now, would you have a different set of reasonable steps, or would be additional reasonable steps?
I would say that we were unfortunate and fortunate to have some other breaches, fortunately not to this magnitude, leading up to this event that actually got us to where we were. So in some ways, I mean, I think that's first of all is how we got as far as we have so far. Have we now since then gone to more facilities that we didn't go to in the past to do this training? Yes, we have. I can tell you our associates all know about this matter, at least at a general level. We've actually have put together some online training tools that every associate has to take in a certain amount of time. And this story is part of, and this matter is part of that video. So we've definitely gone even further to ensure that our associates are advised as to how seriously BD takes its trade secret protection.
Okay, let's just switch topics for a moment. Bob, take this whole Becton situation, and let's assume instead it was trade secrets and competitively sensitive information, that what was stolen were customer names, employee names with their credit card information, with their driver's license information, with Social Security numbers. What would be different here in terms of the company's obligation, having to go to law enforcement, how the reaction would be? I mean, what would make this different in those circumstances?
Yeah, thanks. What might be helpful if you flip ahead to a couple pages where you see the map of the United States, there it is. There are now 47 states that have breach notification laws for personally identifiable information. And you can see there's 2 pending. The challenge is that while there's a lot of similarities, they are not identical. It's not uniform. To some extent, they are mutually inconsistent. Massachusetts is kind of an outlier in certain things. Some will allow a company to do a risk assessment, but is there, in the BD case, clearly something would have gone out. But there may be, what if somebody takes a thumb drive home to work and they can't find it? I'm pretty sure it's in my car someplace, but I can't find it.
Or they lose a laptop, leave it on the subway.
Lose a laptop. So is there an obligation to report on the breach? Well, if it's encrypted, that will take you down one path in certain states. But other states, it doesn't matter. You're not allowed to do a risk assessment. Whether it's encrypted or not doesn't matter. So.
And what's the obligation at that point?
Well, then you have to, depending on each state, right? You'll have to notify the individuals of the breach. Sometimes you have to notify the media. Sometimes the attorney generals. Sometimes law enforcement. It is a relatively complex and somewhat dynamic in the sense that people are changing not only what the law says, but how the law is interpreted. So
now, I noticed that New Mexico doesn't have a breach law.
Yeah.
Would you suggest that people relocate their businesses?
Well, and it's very good. I mean, many states will assert extraterritorial application of their breach laws, so that won't do you any good.
And that means because they include residents of their state, right? I mean, it's personal information belonging to a resident of that.
So if you're in New Mexico, but you happen to have a Texas individual's information that is breached, then that Texas law will likely be triggered. California and Massachusetts are particularly aggressive in how they interpret the extraterritorial effect. So the threshold is what's been disclosed. There is in the FAQs, and we won't spend a lot of time there because I know we're going to cover a lot of things, but some examples under tab 10 of what is personally identifiable information. These are the sort of the typical criteria. There is a constant discussion, robust discussion of suppose something happened. It's not really their name, but they could get the name if you connect the dots kind of thing. So more often than not, I think the default is err on the side of it's probably a breach, and you probably have a notification requirement. And then you're probably going to have to be sending out notifications. And the typical best practice would be at the same time to say we are, obviously the company stands up and says we will, for example, pay for credit monitoring. We'll do a lot of different things. The average breach these days, I think, costs millions of dollars even for a small one. So it is just as though you've got trade secret information or other competitively sensitive information. Maybe the company is not directly harmed other than reputationally, but the exposure they face may be significant. So the first step is, do I have a reporting obligation? You find out what your jurisdictions are. We actually have a live web link at Dorsey, so you can type in the state, and it'll pop up what the triggering criteria are. And then the last point may be you try to make these look as much the same as you can, so you're not treating residents of Indiana differently than residents of Illinois, for example.
And I just want to add one thing. In addition to evaluating what the legal obligations are, it also could make good business sense to inform your customers. For example, I know in our case, there was some information of one of our customers that was in the information that was downloaded, and we thought it was a good idea to proactively inform our customers that some of their information was downloaded. We, at that point in time, did not know necessarily whether it was going anywhere else or not. And I can tell that they took comfort in, one, how quickly we moved, but also that we actually, came to them and explained to them what had happened. And, our sense is that it's happening almost at every organization. So, I mean, they didn't view it as BD being lax with the way their information is being treated. In fact, they viewed it the opposite, and they appreciated being notified.
Now, in the sense of the BD situation, Bob, I mean, obviously, with personal information, you're not worried necessarily about somebody getting on a plane and flying to China with it. But there is a certain element of speed and need to act here, and the laws are different across the states.
That's exactly right. There's a shot clock that starts the minute you find out about the breach, and there's a constant tension, because what you want to do is, how bad was it? Who got affected? How widespread was it? So you want more time. You want more time to figure out what happened. But you've got the number one, the shot clock. You've got typically 30 days, sometimes longer, sometimes less, to get that notification out. But then we all know the example of the major retailer that knew it had an issue, but was trying to figure out how bad was it. They had a press release about to go, and then the blog outed it, and they got beat to the punch. And so if you find yourself, unfortunately, in that situation, you will see that pressure. And one of these we'll talk about is a breach response team that should be constituted well in advance, so that you not only have who's going to step up here, but you've probably done a few dry runs.
And how does law enforcement play this? I mean, we heard Mark describe how they went to the U.S. Attorney's Office, but don't some of these state laws require law enforcement involvement?
Some states require you to notify the local law enforcement. Some states the Attorney General. Sometimes it's tiered. It doesn't always trigger for every state. There may be a minimum threshold beyond which you have to notify the Attorney General, for example. So each law of each state is somewhat individual. There has been, just as an aside, pending for a couple of sessions now, a national breach notification law that I think most people would say please. But
it hasn't happened.
It hasn't happened, and I wouldn't hold my breath.
But there is one with the High-Tech Act, which was passed on health. Maybe you could talk about that for a moment.
Well, the whole separate arena, high-tech and HIPAA, as many of you know, apply to personal health information. So that is a federal standard. So there is uniformity there, but it is somewhat sector-specific. So unlike, say, much of the EU, where it's not sector-specific, doesn't matter what kind of information it is. In the U.S., it is sector-specific. Personal health information gets put into a separate category, national standard, national criteria. Regular old personal information was each state.
Yeah, and I must, sure, go ahead.
Yeah, just a real quick comment. There was an act called the Family Education Right to Privacy Act. Very few people know about it, and it's just as strong as HIPAA.
Yep.
Yeah, and certainly with the High-Tech Act, you're also required, it doesn't only just cover data, but it covers hard documents and paper documents.
You also know the Obamacare, or whatever you want to call it this week, there is a very strong HIPAA compliance, which is much more involved and extended beyond where it was before. HIPAA has been extended excessively for compliance.
Now, the other federal agency is the Federal Trade Commission that's gotten involved in this, right? I mean, they you would not necessarily think that they would be involved in personal data.
Yeah, what constitutes an unfair trade practice is, fairly simply defined as, if you say this is what we will do and will not do with your personal information, and you don't live up to that you violated Section 5, and depending on the severity of the violation, you can expect a visit from the Federal Trade Commission. And thus far, the fines, frankly, have not been overwhelming. I mean, $20 million to Google is not a lot of money. But just a quick aside, the legislation pending in the EU right now says up to 5%, I think, of gross turnover. So we're talking billions of exposure in the EU, and more and more the EU is attempting to get extraterritorial effect here into the U.S. That raises a lot of other issues that we won't get to today, but stay tuned on that one.
Yeah, and on top of it, the consent orders that have come out through the Federal Trade Commission have also required pretty substantial compliance programs to be put in place, right, over, a 10-year period.
Monitoring, typically over 20 years.
20 years.
Facebook, 20-year monitoring period. Yeah.
Going back to the state breach notification laws, is your general advice to comply with the state's strictest provisions, such as Massachusetts and Nevada and things like that, or do you have different advice?
The question was, for those in the, is the general advice, do you try to comply with the state with the most strict compliance and notification requirements? The answer is yes, with an asterisk for Massachusetts. Because Massachusetts says, for example, they don't want you to discuss the circumstances of the breach. Other states will say you should discuss the circumstances of the breach. So it's our practice now is we will have a separate Massachusetts notification letter, and they get their own letters if it's triggered, right? So it is, again, it's now kind of commonplace, so you just live with it. But so very good question. But Massachusetts is an outlier.
And let me also say, in Massachusetts, they also require a compliance program in place that comports with the federal sentencing guidelines and the 7 steps for a valid compliance program. And so this is something we're going to talk about a little bit later as we get towards the end here as to what steps you can take. But certainly I think the trend is going in the way of taking more proactive steps to protect data in the first place as opposed to reacting to a breach and reacting to incidents. I mean, as Bob mentioned before, there are things you need to do in advance, and part of that advanced planning is really having a compliance program in place that deals with that.
Nick, I have one question for Bob. Bob, given the extraterritorial effect of each state, how do you know which notification laws are applicable, like the Massachusetts one?
Yeah, the question, was, I think people heard on the web. So how do you tell, right?
Right.
Typically, we start with the assumption that it's going to be 50 states, because you're going to notify New Mexico. It doesn't matter that they don't have a notification. You're going to tell them. So you start there. But there are times when you can say you can compartmentalize, and there are times when you can rest somewhat easy that this was a localized, if you will, maybe a few states, but you can winnow it down. But yes, I think start with the default. We're going to have a national obligation, and then when you know more about it, as you kind of begin the investigative process, you might be able to say, well, they're only related to this region or something like that. And then I think it's acceptable that if you know that it's only a 5-state region, for example, that's what you have to do.
Yeah, and you can usually tell it by the addresses of the people that had their data stolen. And one state that I really like to avoid, if it's possible, is New Hampshire, because the New Hampshire Attorney General immediately puts it on his website, and everybody picks it up. I mean, there are newspaper outlets out there that cover that website, and that's how a lot of these things get publicized in the national press. The other big area, and let me ask, I'll throw this out to Ed, is the cloud computing, and the use of the cloud has obviously become a big issue. And if you look at Justice Roberts' opinion from yesterday about cell phone usage, which we'll get into in a moment, I mean, really the Supreme Court has recognized kind of the pervasiveness of the cloud and the fact that information can be out there. Have you found that information, personal or even competitively sensitive information, on the cloud has become an issue in terms of what people are out there stealing?
The whole area of the cloud has become an issue, and that's not a coded way to say it's bad or you shouldn't do it. No, it's part of sort of what's happening for companies to reduce costs and be able to have a more rational sort of IT structure. The important thing about the cloud is, what are you putting up in the cloud? What is the agreement that you have with the service provider that you actually are using for these services? And do you know how they actually how they manage your data? The cloud is basically a term that means computers that you don't own, and they have to be somewhere. And some of the systems within the cloud are architected in a way where they will move your data from server to server to be closer to where you are. So that means that we are copying data, or that the cloud service provider is copying data to be closer to where you are. But it is now probably crossing international boundaries, probably now invoking new legal considerations if something is going to go on or take place. And right there you can see, if you listen to all the wisdom you were getting from my colleagues today, that all of a sudden is really complicating the analysis that would be invoked if something goes wrong. Also, I think the key thing is if you're using the cloud to provide data processing horsepower, and you are replicating all of the data that is within the cloud back on your own computers, then that changes the way you analyze the cloud. And I remember Nick and I worked in a situation where there was sort of a cloud-based storage and service providing function, but the client had actually arranged their network so all of the data was copied locally onto their computers. They weren't exactly using it as backup, but it meant if we had a question about the data, we could actually examine most of the data that we needed directly on their own computers. I've seen other situations where companies have outsourced things like payroll into the cloud. Then they had a problem where somebody apparently broke into or compromised the security of the cloud provider. Our client was saying, well, I need to know who accessed my data in your cloud, and the agreement that they were depending upon to get the answers to that question did not compel them to provide this question very quickly. It really stymied the ability of our firm to help our client with the matter because we couldn't get the answers for the information for about 2 weeks. And there was nothing under the agreement that made that illegal or contrary to the terms that were agreed upon. And in some cases, I've also seen where we had suspicions that a compromise occurred inside the cloud. My client wanted information about the access logs from the cloud provider to show who accessed the machine where my client's data was stored, and they didn't want to give it up because obviously it would have provided a compromising situation. And you could tell when we were dealing with this that this is the first time they had thought about this. So I think the important thing to try to be prophylactic in this area is to try to anticipate when you put your data in the cloud. You know the functional benefits you're trying to get. You know the cost savings that you expect to experience. Take that as a given. What other considerations from a security and a legal perspective have you now walked into? And how much of that is contemplated within the agreement that you signed, and where is that going to put you? And talk to some people who've been through this, because we see it coming up quite a bit, and sometimes it's not that big a deal. And sometimes it's an incredible complication.
Yeah, and the agreement really can be everything. I mean, that's really where you kind of negotiate, although if you're dealing with Amazon, obviously your negotiating power is not as great.
You do need to make a differentiation. Amazon runs public cloud, and I prove everything you said is correct. When you work in a private or a hybrid version of cloud, or the provider has specific security considerations added, which are far beyond that of Amazon, that can protect you significantly more. The hybrid environment and the private environment. Amazon only runs public cloud, and they don't want to give you anything. That's just the way they are.
Right. I think just so the people in the WebEx know that the comment was that there's a big difference between Amazon, which runs the public, and what you might get in the private, and Amazon certainly has the hybrid, right. Another question.
Yeah, pretty much every cloud provider that I'm aware of, in their agreement with the user, has a loss of data provision, and they absolve themselves of any liability, even if they're acting intentionally, negligently, willfully, what have you. How successful are users in negotiating changes to those clauses?
I know they're negotiated. It's not something I know. I know we have people that actually that's all they do is negotiate those kind of contracts. It is a burgeoning area, obviously, for the very reason that you're mentioning. How successful, I think it depends on who you are and how much bargaining power you have in terms of how much business you're going to be providing. I don't think anybody on here is really in a position to tell you how that works. There are people who really do that full time.
That's what I do.
Okay. Well, we have a member of the audience that I think after this you two should get together and talk about it, but it is a whole separate area. And speaking of other separate areas, obviously if you're a public company now, the SEC over time has come up with a number of different requirements of disclosure that relate to what companies have to do, and also the stock exchanges are coming up with new rules. If you are interested, I do a column in the National Law Journal, and that issue is being discussed in an issue coming out Monday. If anybody's interested, I'd be happy to send it along to them. But I think we ought to kind of go on to the next topic, which really comes down to, when do you bring law enforcement in, and when do you try and investigate it yourself? And let me ask Ed, who's kind of done it from both ends. At what point do you go to law enforcement, and what point do you do it yourself, or do you do it yourself then go to law enforcement? RJ had mentioned before you really want to bring it on a silver platter with a bow around it. Is that what you really have to do? Kind of give us the skinny on what people ought to be doing with law enforcement if they find themselves in this problem.
Yeah. This is one of those answers where it depends.
And you're not a lawyer, and that's usually the lawyer's answer.
I feel loved now? And it really does. And let me tell you why it depends, and so not to just sort of stop at that being the answer.
And I wouldn't let you stop it.
I think each case is so individualized, and in terms of what is best for the client, not only what they want to do, but what would really be helpful for them. Let me talk. I have a slight bias towards saying maybe lean towards going to law enforcement. Let me tell you where that comes from. First of all, the kind of authority and power you will probably need in order to deal with this, and I think the BD example is a good one. If you were solely limited to civil course actions, never mind search warrants, possible arrest actions, you just can't do that in a civil case. So going to law enforcement can, or at least exploring that option can say, well, here's some horsepower that may be kicked in. Now, it doesn't mean you tell them what to do or that you become, they just become the stalking horse for civil ideas, but that horsepower is there. When you have somebody who steals your information, might have it sitting inside their home or inside their hotel room in this instance, you might want to get that back. Somebody who can actually execute a search warrant, conduct the search, and seize the material. That tends to be a law enforcement option. The other thing I'd say that is very key is that when you go to law enforcement, they can take the facts as you know them. And it's not always a bad insider. Sometimes you're suffering a hack or a penetration. You might know the IP addresses that you've actually checked out. You have some suspicions as to what's occurred. By providing that to law enforcement, they have the ability to compare that information with other investigations that are going on at the same time. And sometimes your one little aspect and what you see, and it may not be so little, is actually part of a bigger picture. And so that dialogue doesn't even have a chance to occur if you're not in a comfortable discussion with law enforcement about what occurred. So yes, you give up some control in that area, but in my experience, and it is not perfect in terms of the way these are working out, and I just had a discussion at the break about this, it's not perfect, but I would say the climate and intent of law enforcement to be a cooperative and friendly force to receive complaints of information is greater now than it has ever been. From the U.S. Attorney's Office, I just heard Preet Bharara, I was on a panel with him 2 weeks ago, make this point yet again, along with the FBI, to say, look, they don't want to suffer not even hearing about these situations because victims do not want to come forward. So generally, you avail yourself of more horsepower for investigative solutions. If it's an overseas action, I think there are advantages with law enforcement. And then the possibility that there is a bigger scheme here that you're connected to, that you would be able to see, all has the chance to occur under law enforcement. Now, that doesn't mean it's always the right thing. We like to have a compatible strategy really with, we don't want to get ahead of legal advice. Go to your lawyers for legal advice and want to be an empowering force for them, but that's how we advise our clients.
But certainly when you give it up to either the U.S. Attorney's Office or the FBI, I mean, you really are not necessarily part of the process at that point. Yeah, I mean, Mark, your situation sounds like you were part of the process to some extent, right?
Part of it, right? But at the end of the day, it's up to now at that point for the FBI and the U.S. Attorney to decide what they think is best. They didn't tell us, for example, tonight we're going to his to his hotel, and they did what they thought was appropriate. And I agree with everything Ed just said. I think it's definitely a tool in the toolkit, and I think it's a very powerful one that worked really well for us. But had we called the U.S. Attorney's Office on that Friday and we just got the sense we didn't reach the right person, or we got the sense that this was one of 7 other major things that he or she were working on, maybe we would have taken a different approach. So that's that. And then the last thing is just recognize that you are now giving up autonomy. It's now going public. As long as it's a civil matter, I mean, it could be picked up, but it's when you go to a civil court. But once it gets to the U.S. Attorney's Office and the FBI is involved, it's a good chance that's going to hit the press. And it hit the press very quickly when this happened. Of course, when there's a search warrant at a hotel, that does tend to hit the press pretty quickly. And I mean, I'll say even, for example, small point, but an unintended consequence, the U.S. Attorney's Office issued a subpoena, asked for his employment file, gave it to him, and they put in one of their pleadings, his person's job title, his responsibility, but they also put his salary in there. And so that was picked up by one of the presses, and then the next day, the manager of this former associate was visited by 2 of his direct reports saying, why was he making more money than him? You got to deal with the fact that this goes public. So.
And you wanted to just add something.
Yeah, just one quick thing to sort of tie together in some of the points that Bob was making. Also, for certain client situations, we have found that when you look at the data breach notification obligations, if law enforcement asks you to cooperate with an investigation by not going public, that can be in certain situations, and again, it's the lawyer's call, a justification or a reason not to have to make the kind of disclosure that you would otherwise.
And that's so provided under a number of almost all of these state laws.
They have that provision, so that's yet another sort of tool to say if you go the law enforcement route, you might actually achieve another objective that's important to you, and if you and your attorneys feel that that's the position you want to be in, realize this is one way to get there.
And we have done these before where there's been a private investigation going on. At the same time, the government's doing an investigation, right? I mean, it's not like it's either or, correct? Right. I mean, you've been involved, and we've been involved in situations where we've conducted an investigation while at the same time we've gotten law enforcement involved.
That's right, and to get the fit right even in that area, I know from my FBI days, you also want to make sure that the private sector actions to take investigation avoid being seen as the stalking horse action for government activity, because otherwise a lot of government sort of obligations can kick in. So how you conduct yourself in this area is important to be designed correctly, documented, appropriately, and executed the right way so somebody doesn't try to demonize it later on and hurt both instances. Both the victim's actions will be demonized and law enforcement will be held to be at fault for using the private sector as a stalking.
And just one minor point to that, I'll just say is that, for example, to provide documentation, we make sure the government issues a subpoena, so just, again, you don't want that cooperation. You want it to really be taking on those 2 separate.
We have a question from the back, but before I take it, I have to, for CLE reasons, read in the code that the people on the a line have to write down for their CLE. It's 296ZX6, and I have to do this one more time. So having said that...
Yeah, just a question. So if you turn over to the FBI or get them involved, what likelihood is there that if they choose not to pursue it, that they're going to tell you that?
Okay, the question is, if you do get FBI involved and they should decide, whether they meet in the U.S. Attorney's Office, if they decide not to do anything with it, what is the likelihood that they're going to tell you that? Part of the problem, and I'll let Ed answer this question after I do for a moment, is that sometimes you just don't know. I mean, a U.S. attorney or an FBI agent is extremely busy, has a ton of other things going on. The key is trying to get to the top of the pile. And sometimes it can take a long time. I mean, what happened with Mark and BD is absolutely, it's unusual in the fact that it went so quickly. I mean, I've never seen anything happen that fast. And you don't always know because they're not telling you, as Mark said, they're not telling you what they're doing when they could be doing things. So sometimes you find out and sometimes you don't. I mean, what's your experience been in that area, Ed?
No, I echo that. I'd say the thing is it's a matter of discretion to a certain degree. Now, many government people are what I call fear-based managers. So their fear is they're managing their fear. They don't want to say something and then later on regret it because circumstances changes and they had to make a change. However, I would say don't manage the fear, manage the problem and the situation and try to help the victim. On my side, I was more open that way and actually give some feedback and kind of let you know. It doesn't guarantee you're going to have the same reaction somewhere else. Sometimes people are just afraid that if they say something, they may come to regret it later. Or, if they want to do some additional investigation to determine whether or not there is sufficient evidence to make this a worthwhile investigation, to say people and the prosecutors are busy, they may need some time to get to that point, and that may take time. So I would say you have the right to ask for feedback. You can't necessarily count on an ironclad answer, but the amount of time that it takes for them to even make that determination is probably going to be little longer than you would expect, because state court actions are more often where somebody comes in, they have a complaint, and as long as the complainant is pressing charges, the police will run with it. In the federal system, it doesn't work that way. There's a lot more comprehensive information that needs to be recognized, and sometimes when you check the bigger picture, the other agents and the other investigations, they don't even know what they're going to do, and they don't want any feedback being provided one way or the other that could in some way play out to the detriment of a bigger investigation. And with the war on terror, I'm telling you, things are a lot more complicated, because even things that seem very simple to the victim, cases of, counterfeit merchandise being sold in Chinatown, can be connected to money laundering operations for counterterrorism investigations. And for any agent out there to be talking to a victim about what's going to happen, what's not going to happen, could really come back, and we've seen it happen, and bite him in the tail. And so as a result, it's not always the most satisfying discussion, but I do think you're entitled to ask the question and maybe ask it a second time. And if they said, look, we're really not at liberty, I'd ask you to respect that.
I have a comment on that.
Well, let's just move on. We got a lot of stuff to cover. One of the issues that you raised, Mark, in your discussion here was, it sounded like the BD people actually did some of the forensic investigation or the computer investigation. And I think one of the things you have to ask yourself is, do we want to have our own internal people do it or bring in someone from the outside? Was that an issue that you dealt with on your situation?
I mean, I'd say in this case, things moved so quickly that we just followed at that point what our normal process was, and and our global information security group does have a protocol in terms of monitoring and a protocol in terms of how when we do get assets back from somebody that's leaving our organization, how there's a lockdown. They do deal with in-house and outside counsel to make sure that they're following the appropriate processes. Even today I'm learning more, and I see that there's certain benefits, either to meet a certain statute or otherwise, to bring in outside of forensic.
Right, but the people that you have in your own, let's say, IT at the time, were they any of them forensically trained, or were these people basically just looked at what happened on the system?
I'd say we have two that have been trained forensically, yes.
Because some companies don't, right, Ed? I mean, you've gone into situations, we've both gone into situations where you get people within a company who think they know what they're doing. And why don't you kind of go through, just briefly, what the problems are when you have somebody who's just kind of the IT person who thinks they're a junior G-man and can investigate, and what can go wrong?
I'll just try to keep this brief. I don't know any forensic investigator out there that says, all you need is the IT guys to tell you what's happened on the network. It's a different skill set. Yes, they're talking about data, but it's one thing to build and run a network. It's another thing to do a logical and thorough investigation to understand what occurred. So the skill sets are different. For example, I was an auditor and a bank examiner and an accountant and a CPA. I didn't know anything about an investigation of fraud until I actually worked with smart assistant U.S. attorneys as an FBI agent. Similar with IT. You can know the technology. It doesn't mean you know how to do an investigation. And another area that is of concern, not only is there a competence and sort of experience that's involved, but very often organizations are organized from the org chart that the same people who are investigating the matter that you're talking about are going to get in trouble for it happening. And anytime you have that kind of conflict, it's unhealthy, and it's a management issue. Don't put people in a position where they're expected to be an expert in how to conduct an investigation just because they know the technology, and don't put the same people in a position who are going to get in trouble for it happening and be expected to give you a clear and objective assessment of what occurred. And if you haven't seen one of these occur, if you start looking at logs and you don't know how to read them, if you don't understand that hackers can delete things from logs, change things in logs, and if you therefore draw erroneous conclusions, you're going to be in a position where you're saying, oh, a lot, and that's not what you want to hear from the investigators.
One point that's follow up on that is that I look at it from a trial perspective as a prosecutor or as representing the companies, and there's things that are being done by IT that are detrimental to the evidentiary value of the evidence that could be completely destroy a case. So you need to have people who are absolutely competent, who are unimpeachable in terms of their ability to do the data. Because I have had situations where IT people looking at data, when they look, but just the mere fact that they looked, they changed the parameters that were in play that were critical to the cases that I had.
Okay, and that brings me really into the next topic of investigative techniques and ethics, which we're going to cover a little bit because I know some people here need ethics credits for their CLE. And I'm going to go through that just kind of briefly, but certainly this whole idea of having an independent person even do an investigation in terms of interviewing people can also be important to avoid any kind of issues of libel or slander where you get somebody who's a manager who conducts the investigation and there may be some animus that may be there or perceived that's there. And the issue is always going to be, well, there's a privilege, but not an absolute privilege to go out and do this investigation. And the only way to get beyond that privilege is to show some kind of malice. And if you've got an outsider doing it, it's a lot less likely you're going to get claims of slander or, you even get in some of these cases somebody brought into a room to be interrogated. There have been false imprisonment claims coming out of this stuff. So I think it's really important that in terms of doing these sorts of investigations, that you do have people who are trained in doing it and that you not necessarily use company people. But keep in mind, as lawyers, when we hire outside investigators, we are really responsible for the acts of our agents, including investigators. And so it's very important that when we go out and we get people to do investigations for us, whether it's someone like Ed who's a forensic person or someone who's simply doing interviews, that we not just sit back and let people do that. You really have to kind of look at what they're doing, how they're doing it, and pass on it, because ultimately we're responsible for what they do, and all of this stuff can come back to bite you if it's not done properly. Obviously, you want to try and keep what's done privileged, although in today's climate, almost everything at some point or another comes out as not being privileged, just because regulators need to know, government agencies need to know. But certainly, I think what you want to do in starting any investigation is to try and at least keep the privilege intact if you can. And a lot of that is simply by making sure that your interview memos or your memoranda that are really starting the investigation make it clear that this is done in anticipation of potential litigation or to provide advice to the client, to the company, whoever that is.
Nick, on that very quick point, also the upjohn factor that comes into play in when you're doing these investigations, that you are a lawyer for the company as opposed to the individual, because sometimes if you do not provide warnings per a Supreme Court case called Upjohn, in terms of that, you may not be able to use that later down the road.
That's absolutely correct. So it's very, this stuff can get, it's not that complicated, but you've got to look at a number of different issues when kind of doing these sorts of investigations. The other model rule of professional conduct that comes into play here is Rule 8.4c, where it states, it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. And this can come up with respect to tape recordings. This has been an issue that's raised where you tape record conversations. And this can also vary across different jurisdictions and states. There are a number of states, such as New York, New Jersey, where one-party consent is enough. And when I say one-party consent, that means one person who knows that the conversation is being tape recorded consents to the tape recording. I have actually had a client who installed a tape recorder in an employee's meeting room where he said to me, well, I consented to put that in there. Yeah, I wasn't in there, but I consented to put it in there. I was ready to kill the guy. That is not what one consent means. It means that one of the parties to the conversation consents. There are other states like California and about 19 other states, Maryland, Pennsylvania, Illinois, Florida, Maryland, where everybody has to consent. You cannot do a tape recording without all the people consenting. And so in conducting any kind of investigation, you really have to know what the law is if you're going to be using tape recordings. Now, I know that, Mark, you had said that before in New Jersey, you had tape recorded this individual's conversation. He did not know at the time, right?
No.
And certainly in New Jersey, that is perfectly lawful. If you had done that in California, that would not have been lawful and would have created problems. What's amazing is even for law enforcement, that can be a problem in some of these jurisdictions. But you also get into an additional problem, which is if you're a lawyer and you're tape recording. Most states will say that it is not disciplinable conduct if a lawyer tape records a conversation, unless somehow you tell somebody you're not tape recording it, and then you're engaging in deceitful conduct. There was an ABA opinion at one time in 2001 that was later withdrawn that would have prohibited lawyers from engaging in secret tape recording. But that no longer is out there. It really goes state by state. The good news, Mark, is in New Jersey there is no rule. We talked about that before. But in New York, you do have a New York City bar opinion, and it states that lawyers may not routinely tape, but may do so in special circumstances, e.g. to advance a recognized public interest where the lawyer is investigating ongoing criminal activity, where threats have been made against the lawyer or client, where the lawyer expects a witness to commit perjury. So there are exceptions to this rule, but I'd say as a general matter, probably not a great idea for lawyers to be tape recording conversations. I just don't think you want to get into that situation. Now, on the other hand, if you've got somebody who is an investigator doing it, that's perfectly legal as long as you're doing it in a state that permits one-party consent recording of conversations. Now, the other huge issue that comes up with respect to protecting data and being able to investigate the types of activity that we're talking about that Becton investigated has to do with the monitoring of computers. And it's extremely important that employees and everybody in the workplace understand that there is absolutely no expectation of privacy, and that the employer is allowed to monitor what goes on in the computers in the workplace. Extremely important that you have very clear rules, and that I even go to the point of having people sign off on these in agreements that are put into employee agreements. There is a case, it's kind of interesting, that was in New Jersey that does not relate to the Becton situation, but it's called the Steingart versus Love Care Agency. This is where an employee who was considering suing her company used the company computers to write to her lawyer, kind of explaining what her lawsuit was, what her issues were. Now, she at least had enough sense not to use the company email. But she did use web-based email. I don't know if it was a Yahoo account or a Hotmail account. So she'd go onto the internet, and what she didn't realize was that every time she did one of these emails, it created a temporary file that fell to what is known as the unallocated space of the computer. And that when a forensic investigation was done, they found all these emails. And so the question was whether or not, even though the policy said that the company could monitor the computers, whether or not the privilege between the employee and the lawyer was still intact. And believe it or not, New Jersey actually said that the privilege was there and came down on some lawyers for using this material. Now, that would not be the rule in New York and most other jurisdictions. And I might ask Ed, this whole idea of a temporary file now going on to the unallocated space where you actually get the email that's written in a web-based email. I know that there's an issue now with solid-state drives. I mean, now kind of computers are moving over from kind of the moving parts of drives to solid state where you're using really flash drive as part of what your computer does. Is this still an issue? I mean, can you still get temporary files off of solid-state drives?
In general, yes, the answer is you can get them off, but they work differently and they're stored differently. A lot of times a temporary file in a traditional hard drive is going to be left and not overwritten as quickly because of the way the geometry of the file works. In a solid-state drive, it stores data differently, and even a temporary file, to the extent it exists, is more likely to be overwritten because it's stacked up differently. So what I would say, without getting too technical, is just realize there is going to be data on a hard drive that you can't see and that you never asked the computer to store. It's stored it. And it may be retrievable, but it is usually only retrievable through a forensic process. It's no longer on the file system. It's in what, as Nick said, the unallocated storage space of the hard drive, these temporary files. And the reason these temporary files could come into existence is mostly to make your computer experience faster and work better. And the way
it's not to catch crooks.
Yeah, it's not to catch. They're not trying to help you with evidence.
Right.
And by doing that, it works faster through RAM and is retrievable faster. When you shut down the computer, a lot of those files are just sort of, the computer ignores them. They're no longer there as far as the computer's file system goes, but they are there as a matter of evidence, and we do always try to look for them when they're relevant.
Question.
By unallocated space, you're referring to files that are deleted, and then you're able to restore those not unallocated space with respect to another partition on the drive, because the operating system wouldn't do that, correct?
Right. You want to respond, Dan?
Yeah, so the question is, what do we actually mean by the unallocated space? It does not mean a partition of a new part of the drive. The simple way to think of it is this. Each hard drive is made up of hundreds of millions of storage sectors. Each sector is big enough to hold like a small document. When the computer saves something because you tell it to, it allocates those storage sectors to holding that file. When you delete it and clear it out, it is then not erased. It's just available for overwriting. And in that case, that sector is now unallocated under the file system. So that is where the term unallocated actually comes from. It's the way that techies think of the file system storage protocols that are used. It does not have to do with a partition on the hard drive.
Because I'm a techie, and that's why.
Did I get it right?
Okay,
Thanks
good.
For the question.
Now, the other issue that really, I think, came up yesterday that was on the front page of the New York Times today was the Supreme Court decision on cell phones. Essentially, the court ruled that in the course of an arrest, if normally when you arrest somebody, you can take whatever they have on their possession into evidence. And as law enforcement, you can go in and within a certain range, you can search for other things, weapons. You see evidence in plain sight, you're allowed to seize that. And the issue before the Supreme Court was whether or not, with respect to cell phones, you could simply seize them and all the evidence that was contained in them without having to get a search warrant. The Supreme Court yesterday ruled that no, you have to get a search warrant. Although they made it pretty easy, saying that, look, you could get it by email, that there are ways to do it by phone, but you do have to get a search warrant. And what's really, I think, probably more significant on this decision than really how it affects law enforcement is how it's going to affect companies and privacy policies, and particularly with the bring to work your own device routine. And how you deal with people's telephones and iPhones and Androids in the workplace. Because if you read this opinion, it is very expansive of the privacy rights that are involved with a cell phone and a smartphone. Even an old flip phone, they even recognized that there were privacy. They really had two phones in front of them. One was a smartphone and the other was a flip phone. And in both cases, they basically recognize that it has in your entire life on it now. That it's really similar to a search of one's entire premises, even more so because it has private diaries. I mean, Justice Roberts talked about most phones have 35 apps, quoted a study where it said that people even have their smartphones in their showers with them now, which I don't understand how you can do. But I think the bottom line is that from the standpoint of companies and dealing with policies, you've got to be certain that you have in place a very clear policy that if people are bringing their phones to work, that the company has the right to retrieve, whether it's phones or computers, data that belongs to them if you're allowing people to work from home. If you're allowing people to use their phones for work purposes, you really have to take into account now very, very seriously how you deal with that from a privacy standpoint, and what do you do when a person leaves. I mean, for example, you've been involved, have you not, Ed, where somebody leaves a company, they have a lot of stuff on a personal computer, and you've kind of acted as a ombudsman to remove it because the employee didn't want their employer to see other things that were personal on their computer. Is that?
No, that's right, and it's coming up more and more where people have a personally owned device, and inside of it is intermingled data. There's stuff that everybody would agree is private, and stuff that is relevant to the company. And we've been brought in a number of occasions now to work out a protocol where a third party, such as our firm, will write up a series of steps that we will execute against that person's personal device. We get both parties to agree that these are reasonable steps. Neither the sort of invading side is not going to see it, but a representative of the third party will. We go through and we look for information that is relevant under the protocol, and we only flag and identify that which is responsive. And in most cases, we show it back to the attorney for the individual who owns the phone and see if there is a privilege to be invoked or not. If there is no privilege, then only that information that is responsive to the protocol is turned over, and therefore you have a way of sort of like protecting privacy but moving justice forward.
Yeah, and I think, look, these are issues I know in light of this opinion yesterday, and I know it just made the news this morning, but I think that's probably going to be the most significant part of the cell phone opinion, that companies really have to now seriously consider how they deal with the bring your own device to work policy. The other thing I want to mention is social media in terms of investigations. There have been a number of cases out there where lawyers have gone onto Facebook, tried to befriend people who they might be deposing in a couple weeks in an investigation, use Facebook as an investigative tool, which has some interesting stuff on it, but you've got to be very careful. I mean, there are opinions out there that say you cannot, again, be deceptive, you cannot come across as somebody who wants to befriend somebody, and particularly if the other person is represented by a lawyer and there's an ongoing lawsuit, it makes it even more dicey. Let me ask you this, Martin. In the course of your investigation, did you guys look at social media with this particular person?
I knew that they looked at it. I don't think there was really anything in there that pertained to BD. So, and to get to that point and a couple other points that I mentioned, we go out of our way when our information security group finds personal information to not look at it. So, for example, in addition to having the appropriate detection mechanisms in place to look for certain things, it's also set up to actually look for access to a bank account or look for access using a social security number, and the program is programmed such that it says you don't want to see that. So.
Nick, on that point, with LinkedIn, that some companies have a policy that you use LinkedIn to promote yourself, to promote your company, to network and things of that nature. And the policies are set up such that you can look at LinkedIn in terms of identifying that. In my Valspar case, we did look at LinkedIn for purposes to get information concerning the individual. Again, to underscore Nick's point, you cannot be deceptive in the least. You cannot pretend to be somebody else. You cannot pretend to be some inquiry on that. But if there's a kind of like a law enforcement, if you are legitimately there and have legitimate access to this point that is publicly available, you certainly can go and look at it. But again, Nick's point is that I think companies need to revisit the policies that they have in place on how to treat not only personal use of cell phones, but iPads and personal accounts and things of that nature, because there's people who use Gmail for purposes of work. There's people who use Yahoo for purposes, who use cloud because it's convenient. It goes back to Ed's point from the very beginning. Sometimes convenience trumps security. Those policies have to be taken.
You've got to take into account, your policies have to take into account the convenience that you want to buy, and that's certainly one way to deal deal with the issue. Now, one of the issues that came up, Mark, in terms of your situation is, I mean, it's kind of interesting. You have a person who is really an insider who steals the information, but yet here was a guy who was ready to abscond to India and be thousands of miles away, and I'm not sure, what the government could have done at that point. Ed, I mean, are you finding that more of these investigations are really involving more of a global community as opposed to just the United States? And if so, how do we deal with that? Because, there's just so much our courts can do, and our law enforcement can do with respect to activity that's directed from overseas or when people take this stuff overseas.
Yes, we see more of this, and it does complicate things. So now we've gone from a situation where we analyze what happens when you have an internal sort of individual doing this kind of activity. It's known, you see what's going on, and might be heading overseas, which you don't want to have happen, and based on the actions that occurred, didn't happen. What if the person is overseas to begin with, or is routing their traffic to make it look like it's coming from overseas, and if you really could trace it all the way back to its origin, you find out that it was back in the U.S. Either way, the trail that you see as the victim is going to show you servers that are inside another country. We see it a lot, and it does complicate things, because you really, not only legally do you have to be careful about what kind of investigations you take, even if you want to go on the ground or get local investigators in that country, you don't know what you're walking into. Organized crime groups are difficult. A lot of times law enforcement is in the pocket of the organized crime groups. Our people can get into trouble. So it really complicates things. You see it quite a bit. And depending on what you're investigating, and I want to be respectful of time here, sometimes they implant code on your computer, and by reverse engineering the code that you see, you can determine something about maybe what the origin of this code is, what kind of language features are in it. They're sort of it's not dispositive, but it's class evidence. And, a lot of times you have pretty good indication that the origin point of the attack coming in not only appears to be coming from outside the United States, it really is. And this, again, starts to bring in the law enforcement card that we mentioned before. I won't repeat the points, but your ability we always like working with a law firm in these situations, and one that's experienced with law enforcement actions and criminal investigations. We say, well, here are some things we could do with law enforcement in the United States that has overseas connections to try to get what's behind this. But it is complicating and vexing.
Okay, let's move on to kind of the area about what we can do to prevent this or minimize it, I guess is probably the best way to talk, and how to respond. And I think this discussion will revolve around kind of 7 areas of risk to the business that really can be looked at in terms of, how do you deal with this problem? And I think we're going to look at it from, several standpoints of people within an organization, depending on the size. I mean, obviously IT is involved, human resources is involved, compliance, legal, risk management. And I think one of the challenges here is getting all of these people to work together, to talk to each other about the issue, and to be a team in terms of dealing with it. And why don't I start with you, Bob, talking about what we can do to sort of prevent this, or because you probably can't prevent it, but to minimize it. Maybe you can talk about kind of the compliance issues that companies ought to be looking at.
Yeah, I think it's probably everybody's got a compliance program to some degree articulated. The question then is, how robust is it? And going back briefly to what we talked earlier today, that there's a game changer out there right now. It's going to be more demanding. A compliance program will ask more of all of us. One of the things that we're looking at is from the board on down. The board is saying, we want this. And you almost have to have the board and the CEO then driving it. So if you get that ownership by the top management, and you really have to sell it there, then the rest goes kind of okay. You do need all the people that were mentioned, and then you have to start getting them in the same place. What are we going to do? How is the commitment going to work? It's a continuous improvement process, to be sure.
I mean, it's really kind of what the federal sentencing guidelines require, and now Massachusetts has adopted on personal information. So, I mean, really what you're suggesting is not just make it for personal information, but really data in general, competitively sensitive information.
Absolutely, data in general, because there's a convergence right now of what the law requires, and pretty soon, what just good corporate practices are going to do, and more people are going to best practices, regardless of whether they're driven there by legal obligations or the CEO has said, we're going to do this.
I mean, even like, for example, the New York Stock Exchange back in 2008 required companies who were listed on the stock exchange to come up with a compliance code that took into account competitively sensitive information as well as personal information. I mean, I think, isn't that where the trend is going now, that compliance is really becoming the key issue?
Yeah, and I think we've got a good question there, Mark, but one last point. Some of you may know that the National Institute of Science and Technology, NIST, has issued some sort of guidelines, right? They're still formative, but my prediction would be that will drive us as well, and you're going to have to acquit yourselves, your companies, saying, how did you go through that process, the NIST process, and you have some flexibility in how you do it, but we will all be held accountable for that, whether it's required by law or there's just now sort of best practices under NIST. And Mark, go ahead.
If you know that point, I was just going to comment that for all these areas, I don't want to understate what Nick brought up, and the fact that it's important that IT and human resources and compliance and legal and risk management are all involved in at least two aspects. In setting a lot of these policies, if you have an exit interview, if you have employment agreements that are being signed, or even how you monitor what your associates are doing. What do you use to determine who should be monitored? And I think there's some that would pass muster and some that might not. So I really think it's so important to have a cross-functional team to address these areas. And the same thing to evaluate activities. I'll just give one story. We saw some activity a few months ago where every single night, it was picked up after about 7 days of this, an associate was downloading information every evening about 5, 6 o'clock and onto some medium and going home. So they would log out and what's going on here? Every single day he's doing this. So we contacted this person's manager, and the manager said, oh yeah, I told him to do it because he asked me for a laptop and we didn't want to give him one. And we're like, so what he was doing, he was going home, putting it on his home computer, which is something we don't want. And he was doing work at night, something we do want, and then he was coming back and starting in the morning where he left off the night before. IT was already to jump all over this guy, and if we didn't bring in other functional managers and the manager and bring in other folks to first assess what the situation is, we could have been again attacking a situation that actually was not the right thing happening, but for the right reasons. So I just think it's very important that when you follow these areas of these areas, that you really do want to bring in a cross-functional team.
Well, let me just talk a moment about hiring practices, because this is actually when someone enters the organization, they get the first introduction to the rules and what the code of conduct is. But it's also an area where you can be defensive. That is, you don't want somebody coming into your workplace with data and trade secrets from a former employer. Because then you can wind up being investigated by the federal government, which they are doing now, if they suddenly think that somehow you enticed this person over because they were bringing not their skills and background, but actual competitively sensitive information to their new employer. Now, Mark, you had an unusual situation with this particular individual. He came over from a company after having stolen their trade secrets, right? When was the first time you guys got wind of that?
We did not know. So first of all, on part of our onboarding process, we do go through confidentiality obligations, and one thing that we do talk about is the fact that we do not want trade secrets or confidential information of the associates' former employees. So that point does come out. Interestingly, when this whole story broke that a person who had formerly been with ED was arrested a week after leaving ED, we did get contacted by another company, and they had suspected that maybe something similar was happening to them. So we did not find that actually about their issues until our issues became public. So this is one of those instances where when one victim comes out, other victims,
Right, but the former employer, is this someone who was a competitor with Becton, or was it somebody just in a different?
Actually, both in the medical device space, and we don't go head-to-head on too many different products, but yes, they are a competitor.
And I guess what do you do if you know you're hiring somebody from a competitor to ensure that they do not bring over with them trade secrets from their former employer? I mean, I would think that would raise red flags, right?
It does, and we get calls, and hopefully we get calls when this happens all the time. We get calls in the IP law group saying, "Mark, can we hire this person?" Sometimes it'll be because they learn that there's a non-compete obligation that person that wants to join our company has, so we have to evaluate that. Other times they just want to hire, let's just say, a rubber specialist from one company to become a rubber specialist at our company, and that other company happens to be a direct competitor. We won't have a problem bringing that person in to work on something else, but if they're working on that same very technology, we're going to have to talk about how we can overcome that obstacle if we can at all.
That raises a great point in terms of there's always a tension between trade secrets, general skills, experience, and knowledge that's acquired on the job. Mm-hmm. Those belong to the individual, no matter what they work on, and they can transport those to wherever they want, provided they don't take the trade secrets with them. And that's always an inherent tension, and your hiring practices have to address that, as well as your exit interviews. They have to deal with those issues, because there are people who use trade secret law as a means to stifle competition and not necessarily legitimately. But
go ahead.
But it's very, very difficult, I think, as an in-house attorney and for an organization that wants to follow the law and wants to be ethical to get it right. And we tend to be somewhat conservative so that to ensure we get it right. And one example is there are times that we will tell one of our business units, you can't hire this person for that role because we think it's going to be too difficult for us to feel good about the fact that they're not using trade secrets or confidential information of their previous organization. But then what happens is an associate from BD goes to another company and is doing working in a similar role, and they'll ask us, "Mark, well, let's go after them now," and it's not that easy to go after them. So, well, you didn't want us to hire that person, and now you're not going after this person. How do you handle that? And we do write letters, and we do remind our former associates of their ongoing obligations, and we will take action if we do see that somebody is violating those.
Now,
it's a tough area.
Right. But let's turn to the issue of company rules. I mean, I assume you guys had a code of conduct. And how did that play into this whole incident? I mean, did you change it afterwards? I mean, did you make any tweaks to it as a result of this incident?
And again, we have tightened up our code of conduct, and we have tightened up our policies as a result of, I think, various, this has become such a focus for our company that I think our language has been tighter. For example, we make it very clear to associates what they can and cannot do when they are entering into our electronic systems. As I said, the language is definitely even more clear. But I'd say that we've been lucky enough now that we're going on a few years since we've had those policies in place. But having a code of conduct, doing training, having employment agreements which say that they have to treat your confidential information and your intellectual property in the appropriate manner is very important. I'll just give one tweak that we've given to our employee agreement. It now says in the employee agreement at BD that you have to, upon giving your termination, at least in the U.S., you have to tell us where you're going. So you're signing and you're obligating who your new employer is. I'm not sure if that would be the case overseas.
Yeah, very quickly, the code of conduct needs to encompass as well the computer use, the cell phone use, and everything else. Because going back to our Valspar case, Valspar had email protocol and a computer protocol. It prohibited the downloading of any software that was not specifically approved by the company. Because in our case, what the research scientist did is he had a little spider that he put on the work computer, and that spider, when he accessed the trade secret database with the formulas, would automatically sync the two, such that on his computer he always had the latest and greatest formulas and stuff like that. And the company specifically prohibited that. And so the code of conduct needs to cover that, and especially in the case that Nick was talking about, the Supreme Court case about cell phone use and bring your phone to work. and what you can do with that phone. And Mark mentioned last night over dinner that sometimes can you use your phone to take pictures or do anything, and those are things that you need to be thinking about.
Let's look at agreements. You mentioned the agreements you have with employees. Has that changed at all since this incident? I mean, you've made tweaks to the agreements as well?
Yeah, so I give one example of the employee agreement where we did look at it again, and we did have already confidentiality covered pretty well. But there are times that associates do not want to say where they're going, and again, we generally don't have non-competes with most of our associates, so the fact that they're moving on is fine. But we do now require them to contractually tell us, where they are going, just so that we could continue to enforce our confidential information. And we've gotten, and just to talk about this, the commingling of company information and private information on either personal assets or on company assets. We've gotten much more strict in our policies about the fact that if you want to use a thumb drive, it has to be a BD-sanctioned thumb drive, which is only has BD information on it and is encrypted. So that in an exit interview, we'll ask, do you have any information on with you? And like, no. Like, do you have any thumb drives? Yeah. Any BD information on there? They're like, yeah. And they hesitate. It's not because they're bad actors. They recognize that they have the fantasy football information on there, and they have pictures of maybe their family, and we don't want that. But we want our information back. And now, as Ed pointed out, it takes you down just a very difficult path. How do you separate those two things? So we've definitely gotten much more strict in getting the message out, not to put BD information on personal assets and not to use BD assets for personal reasons.
Yeah, and one of the other things that I guess we're doing with clients is really advising them to take account kind of these new technology issues in agreements. For example, making it very clear in the agreement that their computer use will be monitored, that the computers belong to the company, that any even personal use, which is permissible, some minor personal use that doesn't interfere with their work, becomes a record of the company, and that they should have no expectation of privacy. This goes back to being able to investigate all of this properly. Judges always like it if employees sign off on these things. They feel more comfortable enforcing them. I've put into agreements that when a person leaves, or at any time for that matter, that the company has the right to look at their personal devices to retrieve data that belongs to the company. You'd be surprised by having that in how often people will just go along with the program and not, kind of argue with you about it. If you don't have it in writing and they haven't signed it, it's a whole different situation. Mentioned before about the Computer Fraud and Abuse Act and being able to set sort of the parameters of one's scope to the access to the computers. I traditionally now put that into employee agreements because that spells it out, and it may be a way to get around what the Fourth Circuit and the Ninth Circuit are now doing with the Computer Fraud and Abuse Act. So I think you've got to look at employee agreements and ask yourself, does this really is it up to snuff with all the new technology that's out there and with the new law that's interpreting this technology? Because I think traditionally they've had post-employment restrictions in them, which are fine. Restrictions against hiring people after you leave from the company, or recruiting people, which also can be very helpful in minimizing your trade secret theft problem. But I think you really have to look at the technology issues that are out there and whether or not your agreements adequately cover those issues.
One quick question?
Sure.
For each of all four of you. Four. And that is, do you recommend as a best practice bricking a personal piece of equipment on a BYOD basis?
I mean, as a best practice, look, it has huge problems. But
The answer is no.
Yes, well, the answer, I can't say no because everybody does it. I do it. And I think that you have to.
The question is in connection with
Somebody
bricking.
to repeat the question.
What was the question?
Yeah, he has to repeat the question.
The question is whether or not we agree with the practice of bringing personal devices.
Bricking.
Oh, bricking.
Not bringing.
Bricking, I'm sorry.
Whereas the policy pursuant to an agreement, onboarding, allows the company to basically make the telephone, iPad, and tablet bricked, so it can't be used when the person leaves, or it's lost.
Or it's wiped.
Right. So the answer is, do we agree with that? Once the
As a
person-
best practice.
They're aiming at me. I don't have a standard answer on that one. I think what we look at is risk management. And to the extent that that is one way to manage your risk to a certain level, it's one way to get there. If that's going to clash with your culture, and really, or you can't get good legal, you don't want to be at odds with legal, then you won't. So we don't look at it as necessarily best practice, but rather a tool or a technique that could bring you to the risk management level that you want to achieve.
But the other way to do it is simply to have a policy of review to make sure anything that belongs to the company is taken off and, in a sense, bricked.
I would take it so far and say that is, in my view, the better practice. And there's a couple things you need to do. One, in terms of the agreements, you need to make sure that everything that's being worked on during the company belongs to the company. So assignments and records of invention and all the things and everything that's done, you need to make that clear up front. Also, you need to make very clear how they can use their computer or any system outside the workforce. And your policies need to address that in terms of, and I would go into bricking, especially if I'm dealing with HIPAA-related stuff. If I'm working for one of our clients, United Health Group, and I'm dealing with a lot of claim handling aspect of things, yes, you need to have capabilities of where you can use the computer, how you can use the computer, where you can leave it, and being able to wipe the computer from a remote location if necessary. And the same thing would apply to policies with respect to cell phones, iPads, the whole thing. You need to think of it holistically. The more important your stuff is, the more you need to brick. I mean, I would argue that if your trade secrets are so important, and you let somebody just put them on a thumb drive and walk out with them and stuff like that, it becomes a matter of reasonable measures. Was that a reasonable measure? Under certain circumstances, sure, if you're talking maybe competitive data.
Yeah, and it really, it's almost an economic analysis of what is reasonable in terms of what you're trying to protect.
If I may, three other components. One is the hierarchy of risk, as Ed said. I mean, I think there may be some people that, yes, for this group of employees, we are going to have a heightened level of security, and that would do it. Number two, we're going to get there. I think we're going to be driven to things like that. And so from a cultural standpoint, I mean, it's always a challenge, but I think we're going to have to evolve to get to where you're talking about. Number three, cutting against both of those may be what, if you're a multinational and you've got employees, Finland is a really difficult place to do business. Germany's not so hot either when it comes to these kinds of issues, and then you really will have to be careful having a corporate-wide policy that would apply multinationally, because you probably are not going to have that kind of flexibility in all jurisdictions.
Okay. Use of technology. I mean, obviously, let me ask you this, Mark. Did you do anything, Becton do anything with their technology and their IT in response to these incidents afterwards to make it more difficult for somebody to steal?
Again, I'm bolstering up our policy as far as what sort of assets can be used is one, but the one that I brought up a little while ago, the one that we're very close to having a policy on is and we're not there yet, but it's very close to having a policy on, is the use of USB ports. We have some in the organization that feel USB ports should be shut down in terms of allowing data going out of those USB ports, and you would just need to have you have to get permission when you want to download documents. And then others that say that's a little too inconvenient, and it's unclear to me which way we're going to ultimately land on that one.
And how about the termination practices? I mean, obviously you use part of that in trying to uncover more evidence here. Has that changed any in terms of how you're dealing with people who are leaving, particularly people who might be leaving to a competitor?
Yeah, so at BD, we now, it happened more on an ad hoc basis, and now it's happening we have a really good process as far as who should be contacted when somebody tenders their resignation. And it depends on who it is. I mean, an administrative assistant is going to be treated differently in terms of the level of attention that they may or may not get versus, say, the vice president of R&D and that person who's going to a competitor versus who's not going to a competitor, and how long they were with the company. So we have really evolved quite a bit in terms of what our process is in terms of bringing in legal, and what those exit interviews are like, and what we're asking for. Immediately, when somebody now tenders a resignation, I can tell you IT is contacted immediately. That didn't happen in the past. Legal is contacted immediately. HR was always contacted immediately. Right. But bringing in IT and legal happens sometimes. If it was somebody at high level, R&D, going to a competitor, they probably brought us in right away. It's not just those exceptions now where we're being brought in. We're being brought in on a much more commonplace.
Okay, and I think finally, just to touch upon the protocols for response, I mean, I think one thing that comes out of this is, I don't think I think maybe it was Bob that said it's not a matter of if it's going to happen, but when it's going to happen. And do you have in place the sort of the mechanisms to deal with this so that you're not scrambling to find the right people, to find the right investigator, to find the right resources that you need to deal with a breach.
And Nick, I might actually go a step further, and I would bet in many organizations it is happening. I mean, depending on what it is, but I mean, I think whether it's an associate who's just taking 2 or 3 documents or 2 or 3 files, and not necessarily for the most nefarious of reasons, all the way to the extreme of somebody downloading thousands of documents, I agree. It's not a matter of if, it's a matter of when. But in many organizations, it might be happening.
And they don't realize it. Right. Okay, it's exactly 12 o'clock. If we have any other questions, we'd be happy to take them. But I have to provide the code again, 296ZX6. But if anybody has other questions, we'll be sticking around for a bit. And thank you.
Thank you.
Thank you, Mark, for sharing the whole Becton
Oh, nice working.
I very much enjoyed it. Thank you.
Yeah, thanks for coming over.
Nick, great job of organizing.
Great job, yes.
Yeah.
That was a lot.
Although I think Mark